Look, what?
Okay,
So,
sorry.
no,
They want to start you first.
that's okay, that's okay. Thank you.
You're welcome. Good morning, this is LaMonaco.
Thank you very much.
Okay, you're welcome.
Good morning, sir.
So how are you?
Good. We're just going to start momentarily, okay?
No problem, thank you.
You're welcome. Attorney Sirica, you're all set to go?
Yes, I am.
All right, we're going to begin. I am Parole Officer Menard, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Kevin LaMonaco, inmate number 405104. Today is Thursday, July 30th, 2026. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Yes, sir, my name is Kevin LaMonaco, inmate number is 405104.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Attorney Sirica. Can you please identify yourself for the record?
Sure. Attorney Alfonso Sirica with the Parole Revocation Unit on behalf of Mr. LaMonaco.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. LaMonaco, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, the evidence that you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth. So help you God, or upon penalty of perjury?
I do.
Thank you. You can put your hand up. We're going to go over the procedure of the hearing. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, sir.
All right. We're going to go over your rights. You have the right to be represented by an attorney at this hearing and counsel is present. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes.
You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, sir.
Okay. We will now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. For charge number 1, reporting, you were scheduled to meet with your parole officer on August 20th, 2025, and you were scheduled to meet with your parole officer between 9 a.m. and 11 a.m. at your parole approved residence. Your parole officer reported to your residence at 10 a.m. on 8/20/25, and you did not answer the door nor respond to phone calls. Your GPS unit showed that you were inside your residence at that time. Charge number 2, GPS. On August 5th, 2025 at 1:12 a.m., you left your parole-approved residence and did not return until 4:36 a.m. This is a violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 6, 2025, your GPS shut down at 8:23 a.m. and you did not charge it until 11:26 a.m. on that day. This is in violation of your charging responsibilities on number 4, your GPS agreement. On August 10th, 2025 at 1:49 a.m., you left your parole-approved residence and did not return until 2:09 a.m. This is a violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 10th, 2025 at 9:40 p.m., you left your parole-approved residence and did not return until 10:08 p.m. This in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 11th, 2025 at 1:25 a.m., you left your parole-approved residence and did not return until 2:07 a.m. This is a violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 16th, 2025 at 1:36 a.m., you left your parole-approved residence and did not return until 2:25 a.m. This in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 18th, 2025 at 9:04 p.m., you left your parole-approved residence and did not return until 9:46 p.m. This is in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 19th, 2025 at 12:46 a.m., you left your parole-approved residence and did not return until 1:07 p.m. 1:07 a.m. This is in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 19th, 2025 at 10:13 p.m., you left your parole-approved residence and did not return until 11:22 p.m. This is in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 20th, 2025 at 5:08 a.m., you left your parole-approved residence and did not return until 5:49 a.m. This is in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 20th, 2025 at 9:04 p.m., you left your parole-approved residence and did not return until 11:43 p.m. This in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 21st, 2025 at 6:20 a.m., you cut the strap of your GPS unit. Your whereabouts have been unknown since then. Charge number 3, curfew. On 8/5/25 at 1:12 a.m., you left your parole-approved residence and did not return until 4:36 a.m. This is in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 10th, 2025 at 1:49 a.m., you left your parole-approved residence and did not return until 2:09 a.m. This is in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 10th, 2025 at 9:40 p.m., you left your parole-approved residence and did not return until 10:08 p.m. This is in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 11th, 2025 at 1:25 a.m., you left your parole-approved residence and did not return until 2:07 a.m. This is in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 16th, 2025 at 1:36 a.m., you left your parole-approved residence and did not return until 2:25 a.m. This is a violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 18th, 2025 at 9:04 p.m., you left your parole-approved residence and did not return until 9:46 p.m. This is in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 19th, 2025 at 12:46 a.m., you left your parole-approved residence and did not return until 1:07 a.m. This is in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 19th, 2025 at 10:13 p.m., you left your parole-approved residence and did not return until 11:22 p.m. This is in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 20th, 2025 at 5:08 a.m., you left your parole-approved residence and did not return until 5:49 a.m. This is a violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. On August 20th, 2025 at 9:04 p.m., you left your parole-approved residence and did not return until 11:43 p.m. This is in violation of your 9 p.m. to 6 a.m. curfew per your GPS agreement. Charge number 4, program participation. On August 21st, 2025, you failed to report to your mental health provider, Community Resources for Justice. Subsequently, you were discharged due to noncompliance with attendance requirements. Charge number 5, residents. On August 20th, 2025, you packed your belongings at your parole approved and told the house manager that you were not going to return and you have no other parole approved residents. Charge number 6, absconder. On August 20th, 2025, you packed your belongings at your parole approved and told the house manager that you're not going to return. You have no other parole approved residents. You have made no effort to contact your parole officer, nor have you responded to your parole officer's attempt to contact you. Charge number 7, drugs. On August 1st, 2025, you rendered a urine that was positive for cocaine. The sample was sent to Premier Biotech Labs and returned with confirmed cocaine positive on April 15th, 2025. On May 15th, 2025, you rendered a urine that was positive for cocaine. The sample was sent to Quest Diagnostic Labs and returned with confirmed cocaine positive on May 22nd, 2025. On August 4th, 2025, you rendered a urine that was positive for cocaine. The sample was sent to Premier Biotech Labs and returned with confirmed cocaine positive on August 10th, 2025. On August 12th, 2025, you rendered a urine that was positive for cocaine. You signed a voluntary drug admission admitting to using cocaine on August 10th, 2025. Charge number 8, travel. On May 29th, 2026, you were located by Fort Pierce, Florida, by local law enforcement. You did not have permission to leave the state of Connecticut. On charge number 9, search. On August 20th, 2025, you were scheduled to meet with your parole officer at your parole-approved residence between 9 a.m. and 11 a.m. Your parole officer reported to your residence at 10 a.m. on August 20th, 2025, and your GPS unit showed that you were inside your residence at that time. You did not answer the door nor respond to phone calls, thereby refusing entry of parole into your parole-approved residence. Charge number 10, mental health evaluation treatment deemed necessary. On August 21st, 2025, you failed to report to your mental health provider, Community Resources for Justice. Subsequently, you were discharged due to noncompliance with attendance requirements. We're going to now identify exhibits. The state has filed the following exhibits that have been marked for identification purposes. Exhibit A, remand to actual custody order. Exhibit B, signed conditions of parole. Exhibit C, signed notice of parole violation with rights. Exhibit D, parole violation report. Exhibit E, signed GPS monitoring agreement. Exhibit F, State of Connecticut signed offender misconduct reports ×2. Exhibit G, Quest Diagnostics lab report collected on April 1st, 2025. Exhibit H, Premier Biotech lab reports collected on May 15th, 2025. Exhibit I, Premier Biotech lab report collected on August 4th, 2025. Exhibit J, signed voluntary drug admission dated on August 12th, 2025. Exhibit K, Fellowship Halfway House incident report, incident date April 1st, 2025. Exhibit L, Fellowship Halfway House discipline report, incident date May 15th, 2025. Exhibit M, letter from Courtney Ring, LMSW, family reentry dated August 29th, printouts times 6. Exhibit O, Board of Pardons and Paroles Revocation Summary dated August 8th, 2023. Exhibit P, Board of Pardons and Paroles Revocation Summary dated November 12th, 2024. Exhibit Q, Waiver of Extradition. In addition, the state has filed an addendum to the parole violation report that states, in reference to the parole violation report submitted by P.O. Bennick regarding Kevin Monaco, inmate number 405104, the following applies. On September 8th, 2025, the Board of Parole issued a warrant based on that report declaring the offender an absconder from the parole special supervision. On September 10th, 2025, the case was transferred to FIU for investigation. On May 29th, 2026, Lamonaco was arrested by the Fort Pierce Police Department and charged as a fugitive from justice. A detainer was lodged with Fort Pierce Police Department. Lamonaco was served with parole violation notice on June 13th, 2026, and the signed notice of parole violation, parolee rights, and remand were scanned into case notes on June 15th, 2026. This is the second time that Lamonaco has absconded from Connecticut and been apprehended in Florida. Did you receive a notice of the parole violation report, and the other documents I just marked for identification purposes?
I did.
And did you review those?
Yes.
The defense has filed the following exhibits, which are marked as follows. List of parole accomplishments and future plans for parole reinstatement. Exhibit 2, support letter from Nicole SARS. And Exhibit 3, employment letter from Patrick Burton. Attorney Sirica, did you request that any witnesses be allowed to testify at this hearing?
No, just Mr. Lamonaco is going to be giving some testimony.
All right, Attorney Sirica, is now your opportunity to call any witnesses, present evidence, and speak on any evidence submitted.
Yeah, just briefly. Kevin, you heard hearing examiner rattle off 10 charges brought against you, correct?
Yes, sir.
All right. You're not disputing the fact you were picked up in Florida?
No, sir. I take full responsibility.
Okay, and when you picked up in Florida as a fugitive, you didn't pick up any criminal charges while you were there, correct?
No, sir.
Okay, and is it a fair statement, Kevin? It appears on April 1st of 2025 was your first positive urine, and from April of 2025 to August of 2025 is the period of time where things went downhill for you. Is that a fair statement?
That's fair, but I got a little confused because I did render a couple clean ones so that I can move out of the halfway house to get my own house, and so I don't know why those weren't accounted for.
Yes, they don't post the clean ones, just the dirty ones that they use for your violation. And I just want to hear an examiner know. So April 1st of 2025 till August of 2025. Is that a fair statement? During that time frame, that was your relapse phase?
Yes, sir.
Okay. And is there a fair statement at some point you realized the violations and that's why you went to Florida?
That's correct, sir.
Okay. And when you were picked up in Florida, you voluntarily signed an extradition to be brought back to Connecticut, correct?
Yes, sir.
Okay. And you've also been advised, Kevin, because as the hearing examiner already put on the record, they've apprehended you in Florida before. You've been advised that there is a process called the Interstate Interpact Agreement in order for you to legally get to Florida, correct?
I am now educated about that. Yes, sir.
Okay. And is it a fair statement you got picked up by Florida May 29th of 26. You were remanded by Connecticut on June 13th of 2026. So you've had a bit of time since you've been incarcerated to think about how you went about this and how you're going to go about it the next time there's an issue, correct?
Yes, sir.
Okay. And since you've been incarcerated, we'll cover this a little bit in the second part. You didn't attempt to roll. You're on the waiting list for programs to get some help in the facility, correct?
I am, and I'm also enrolled in vocational school because I'm trying to finish my associate degree in manufacturing, which I did start my Pell program when I was in McDougall, or CDL, whatever comes first.
Okay. P.O. Menard, I just want to put on the record, from day one, Mr. Lamonaco, he took responsibility for what occurred here. As you can see, some of these violations go back to April of 2025. He self-admitted the substance issue is a big issue for him. He does want to get help, and I do give him credit. Yes, he didn't follow rules. He went to Florida, did not pick up any new criminal charges there, and he is willing to do treatment and abide by the Connecticut parole conditions in order to at some point get to Florida. But I'll speak about that at the second part of the hearing. But I just wanted to give you an idea as to what occurred here. Thank you.
Thank you. Any other closing statements, Attorney Sirica, before I make my
Not at
findings?
this time, just about his background at the appropriate time, please.
I will now take a moment to review the case and will notify you of my findings in a moment. For charge number 1, I find that you violated the condition of reporting based on the evidence presented in State's Exhibits B and D. For charge number 2, I find that you violated condition of GPS based on the evidence presented in State's Exhibits B, D, E, and N. For charge number 3, I find that you violated condition of curfew based on the evidence presented in State's Exhibits B, D, E, and N. For charge number 4, I find that you violated condition of program participation based on the evidence presented in State's Exhibits B, D, and M. For charge number 5, I find that you violated condition of residence based on the evidence presented in State's Exhibits B and D. For charge number 6, I find that you violated condition of absconder based on the evidence presented in State's Exhibits B, D, and Q. For charge number 7, I find that you violated condition of drugs based on the evidence presented in State's Exhibits B, D, G, H, I, and J. For charge number 8, I find that you violated the condition of travel based on the evidence presented in State's Exhibits B, D, and Q. For charge number 9, I make a no finding on the condition of search based on insufficient evidence provided by the state. For charge number 10, I find that you violated condition of mental health evaluation and treatment deemed necessary based on the evidence presented in State's Exhibits B, D, and M. That concludes the fact-finding portion of this hearing. Before I make my recommendation, you will have the opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. Attorney Sirica, do you wish to make a statement regarding the violation background and history at this time?
I do. Yes, on behalf of Mr. Lamonaco, my client, he's 38 years old. He was born in New York and raised in Danbury and Waterbury. He receives his primary support from his fiancee, Ms. Sars. His one son is age 22. Upon his previous release from Osborne, he did successfully complete the Fellowship House Ministries Halfway House program in Groton. That's in February of 2025. He did receive his GED and also has taken some classes online, 14 credits in advanced manufacturing through Esnato Community College. As far as employment here in Connecticut, he did have a full-time job at McDonald's in Groton for approximately 8 months. And although in absconder status, he was still working a full-time job in Florida, and the owner of the company did submit a support letter on behalf of Mr. Lamonaco. And then his previous positions, he did have a full-time at Mohawk Industries in Torrington. He was there for approximately 2.5 years until he moved to New Britain and obtained a new job, also a part-time job as a cook at Chili's. He did report to us, he did participate in outpatient mental health treatment services at Community Resources for Justice in New London, and then previously did participate in outpatient services, including individual group therapy and medication management at Wheeler Clinic in New Britain. As he indicated, he is enrolled at the Advanced Manufacturing Program at Robinson Institution and is on the waiting list for new thoughts. He is amenable to being placed in a halfway house in Hartford as his first choice. As I already put on the record, his ultimate goal is to get to Florida. He has family there, has support there, with the understanding, though, that he needs to remain in compliance in Connecticut for a period of time before Connecticut will consider the interstate compact agreement transfer. He's amenable to all treatment recommendations, specifically for the substance abuse. That's kind of what led him down this path. So he knows what he needs to do. I believe he's on supervision until 2032. So he has some time to get things in order, because he was advised by me, actually, if he keeps coming back, things are going to get worse for him. He is willing to get things in order so he can do this correctly. Mr. Lamonaco, Kevin, anything you want to add regarding your background or what you're going to do when you get out as far as treatment and not go to Florida until you have specific written permission from the parole officer through the interstate impact agreement to get there?
Yes, sir. Well, I take full responsibility for everything. I don't want to sit here and give you guys any excuses. Look, what I did was a bonehead decision. I know what I did. I just wish I was educated earlier before about the interstate compact and, regulations and how it goes about. And maybe I would have done better before instead of making this bonehead decision and cutting my bracelet off and going over there. But I do have a great support system over there. I love my fiance to death. I love my job. My boss is great. The owner is great. I have a great gig over there. I'm blessed to say that he's given me a reference and a recommendation letter saying that I still have a job there, which I'm very lucky about that. I'm blessed with that as well. Like I said, I don't want to use my background or my history as an excuse or as a crutch. I know what I did was wrong. I take full responsibility once again. I know what I need to do. I just want to go about it the right way this time and not make any more mistakes. I'm grown, I shouldn't be making these bonehead decisions and, making myself look as bad as it is, you know what I mean? But every time I do go over there, I do great. I have not been on mental health meds for about a year now, and my brain feels pretty good. I'm not foggy and cloudy headed. I feel like I'm able to think. I feel good, physically, I feel good mentally. I'm great spiritually. I just need to do what I have to do, and I just want to go about things the right way. And once again, for the last time, I take full responsibility, and I apologize to the boards for the misconducts that I've done and the bonehead decisions that I've made.
I appreciate your comments. I appreciate your honesty. I don't have anything else to add, Peel Menard.
Okay, thank you. Before I make my recommendation, I just want to state on the record, this is your third special parole violation, 1 criminal and 2 absconding. Both times Mr. Lamonaco absconded and went to the state of Florida. You were also out in the community for approximately 6 months before you absconded. I've listened to the testimony and reviewed all the evidence provided. Based on that, I recommend that your special parole be revoked with a new re-parole date of June 14th, 2027. This is an approximate 1-year sanction. This sanction is calculated from the date you were remanded to custody. The following conditions are recommended for your special parole release: halfway house placement, behavioral management, anger management, and domestic violence, no alcohol consumption, no contact with victims A, B, AD, and NM, general no contact with AF, and mental health evaluation. My findings and recommendations will be forwarded to the board on August 13th, 2026. You should receive the official written decision from the board within a week from that date. The board may lessen the recommended sanction or let my recommended sanction stand. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing will be held. Before the hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. During the supplemental hearing, you'll have an opportunity to respond to those specific reasons while in front of the panel of the board. This concludes the revocation hearing. I'm now going off the record.
If I may. So Kevin, it's going to the board on the 13th of August. You and I will get something in writing about a week later with the final outcome. As I told you, they can adopt, they can lower it, or they can increase it. If by some chance they want to increase that, there's another hearing. I'll set up a legal call with you to go over that with you. So just hang tight until we get that report after August 13th, okay?
All right, thank you for the
All right,
opportunity.
good luck to you, Kevin.
All right, thank you. We all set?
Yes, you're all
Yes.
set. Thank you.
Have a good day. Blessings.
You too.
Thank you, Appeal Menard.
Thank you.
Finish. Right there, I need the first one.
Let's go back.
Yes, you can come back. The same way, thank you.
Just give me 1 second, Mr. Diaz. I'll be right with you, okay?
No problem, sir.
Okay, good morning. I'm Parole Officer Menard, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Ernesto Diaz Gonzalez, inmate number 161546. Today is July 30th, 2026. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Ernesto Diaz Gonzalez, inmate number 161546.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. There's no attorney or parole officer present. This is a preliminary hearing which has 3 purposes under Connecticut law. 1, to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. 2, to determine if the act is sufficiently serious to warrant the revocation of your parole. And 3, to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated 1 or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that the preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Is it Diaz Gonzalez or Mr. Diaz?
Mr. Diaz, sir.
Mr. Diaz, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you should give concerning this case shall be the truth, the whole truth, and nothing but the truth. So help you God, or upon penalty of perjury.
Yes, sir.
Okay, you can put your hand down. Thank you. So we're going to go over the procedure for the hearing. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits for the record, filed for the record. State is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, sir.
Okay. You have important rights at this hearing, which I will now review with you. You have the right to be represented by an attorney at this hearing. You may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that an attorney could represent you at this hearing?
Yes, sir.
Do you intend to seek counsel for this hearing or proceed without counsel?
Proceed without counsel, sir.
Okay. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes, sir.
You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, sir.
We will now review the charges that the state your parole officer is bringing against you and the information underlying each charge. For charge number one, reporting on June 22nd, 2026, you were instructed by this PO to report to the Hartford District Office on July 7th, 2026. You failed to report to this PO and failed to make contact. You are in violation of special parole condition number 1, release directions. On July 8th, 2026, you left a message with the Hartford District Office staff. You left a message stating that you were going to report to the Hartford District Office at 1 p.m. You failed to report to the Hartford District Office. You were in violation of special parole condition number 1, release directions. Charge number 2, GPS. On March 2nd, 2026, you read, signed, and received a copy of your GPS monitoring agreement. On June 28th, 2026, you violated your 9 p.m. to 6 a.m. curfew. You were observed out of your residence between 4:52 a.m. to 5 a.m. You were not given permission by this PO to leave your residence during this time. You were in violation of GPS monitoring agreement number 11 and your special parole condition number 1, release directions. On July 1st, 2026, you violated your 9 p.m. to 6 a.m. curfew. You were observed arriving at your residence at 9:16 p.m. You were not given permission by this PO to be out past your 9 p.m. curfew. You were in violation of your GPS monitoring agreement number 11 and your special parole condition number 1, release directions. On July 2nd, 2026, you violated your 9 p.m. to 6 a.m. curfew. You were observed arriving at your residence at 9:23 p.m. You were not given permission by this PO to be out past your 9 p.m. curfew. You were in violation of GPS monitoring agreement number 11 and your special parole condition number 1, release directions. On July 3rd, 2026, you violated your 9 p.m. to 6 a.m. curfew. You were observed leaving your residence at between 4:10 a.m. and 5 a.m. You were not given permission by this PO to leave your residence during this time. You were in violation of GPS monitoring agreement number 11 and your special parole condition number 1, release directions. On July 3rd, 2026 into July 4th, 2026, you violated your 9 p.m. to 6 a.m. curfew. You were not seen in your residence between 9 p.m. and 5 a.m. On July 5th, 2026, you failed to keep your GPS monitoring device battery charged. Your GPS unit shut down at 5:05 a.m. and you failed to recharge your GPS battery. Your whereabouts were unknown between July 5th, 2026 and July 10th, 2026. You were in violation of GPS monitoring agreement number 4 and your special parole condition number 1, release directions. Charge number 3, curfew. On June 28th, 2026, you violated your 9 p.m. to 6 a.m. curfew. You were observed out of your residence between 4:52 a.m. to 5 a.m. You were not given permission by this PO to leave your residence during this time. You are in violation of GPS monitoring agreement number 11 and your special parole condition number 1, release directions. On July 1st, 2026, you violated your 9 p.m. to 6 a.m. curfew. You were observed arriving at your residence at 9:16 p.m. You were not given permission by this PO to be out past your 9 p.m. curfew. You were in violation of GPS monitoring agreement number 11 and your special parole condition number 1, release directions. On July 2nd, 2026, you violated your 9 p.m. to 6 a.m. curfew. You were observed arriving at your residence at 9:23 p.m. You were not given permission by this PO to be out past your 9 p.m. curfew. You were in violation of GPS monitoring agreement number 11 and your special parole condition number 1 release directions. On July 3rd, 2026, you violated your 9 p.m. to 6 a.m. curfew. You were observed leaving your residence at between 4:10 a.m. and 5 a.m. You were not given permission by this PO to leave your residence during this time. You were in violation of GPS monitoring agreement number 11, your special parole condition number 1 release directions. Charge number 4, program participation. On June 22nd, 2026, you were instructed by this PO to follow up with the Root Center for IOP services as a part of your inpatient aftercare plan. This PO was advised by the Root Center on July 7th, 2026, that you did not follow up for IOP services. You are in violation of special parole condition number 1, release directions. Charge number 5, drugs. On April 21st, 2026, you rendered a urine screen that was sent to Premier Biotech to test for cocaine substances. Premier Biotech returned results on April 29th, 2026 and confirmed that you were positive for cocaine. You are in violation of special parole condition number 2, obey all laws. April 28th, 2026, you rendered a urine screen that was sent to Premier Biotech to test for cocaine substances. Premier Biotech returned results on May 1st, 2026 and confirmed that you were positive for cocaine. You were in violation of special parole condition number 2, obey all laws. On May 5th, 2026, you rendered a urine screen that was sent to Premier Biotech to test for cocaine substances. Premier Biotech returned results on May 10th, 2026 and confirmed that you were positive for cocaine. You are in violation of special parole condition number 2, obey all laws. On July 10th, 2026, you verbally admitted to officers to using cocaine substances and rendered a urine screen. Your urine screen was sent to Premier Biotech to test for cocaine substances. You are in violation of special parole condition number 2, obey all laws. The state has filed the following exhibits pre-marked for identification purposes. Exhibit A, Connecticut Conditions of Parole. Exhibit B, Connecticut Board of Parole Remand to Actual Custody Order. Exhibit C, Notice of Parole Violation / Notice of Parolee Rights. Exhibit D, Parole Violation Report. Exhibit E, GPS Monitoring Agreement. Exhibit F, Allied Universal GPS History. Exhibit G, Misconducts. Exhibit H, Premier Biotech Technology Results. And Exhibit I, State of Connecticut Board of Pardons and Paroles Decision Information Summary. Mr. Diaz, did you receive the notice of parole violation, the parole violation report, and the other documents I just marked for identification purposes?
Yes, sir.
And were you able to review this information?
Yes, sir.
No defense exhibits have been filed. Today we have no witnesses. Did you request any witnesses?
No, sir.
No. All right. Now is your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you so choose. At this time, you may question any witnesses if you have called any or testify regarding your case. Would you like to respond to the charges at this time?
Actually, sir, I had spoke to my first PO officer, and some of the issue was I was buying my marijuana, and it was not from a dispensary. Some of them tested positive for cocaine, and May 7, when I called my PO that I was coming in, the reason I didn't go in, sir, I had an appointment with CT Addiction for my Suboxone, because I didn't want to come in without being, how can I say that, without being dosed. So on the following day, I got dosed, and I went straight to my PO, and I explained to her, you know, and I sat at the desk, and I basically turned myself in. You know, and but I do take full responsibility. I cannot blame the cocaine on the marijuana. It is my fault. I should have been more aware of myself and my surroundings, sir.
Okay. Anything else that you'd like to add before I announce my findings?
Well, actually, based on the root center, because I was doing two things at the same time. I was taking treatment at the root center and CT addiction on Main Street because I was on methadone, so I took myself out. They moved me from methadone to Suboxone, so I had to go to CT addiction, and that was one of the reasons why I wasn't on at the root center, but I was at CT addiction, and that's when I called my PO, and that's what I was coming in. But the CT addiction didn't have my Suboxone ready for me to dose. They told me to come back the next day, where that was a Friday. So I went Friday, I got dosed, and I went straight to my PO.
Okay.
Based on the time, sir, with all due respect, I know there's no excuses, but I thought it was at 5 a.m. that I could be out looking for jobs, for work and stuff like that. I didn't know it was 6 a.m.
You weren't aware that when you signed that was 9 p.m. to 6 a.m.?
But honestly, sir, with all due respect, I just signed the paper. I ain't even read it, sir. Because honestly, last time that somebody told me it was 5 a.m. When I was at Sober Solution, we was allowed to go out from 5 a.m. to 9 a.m. So I figured it was the same routine, but I was wrong. So that's my fault.
Okay. All right. Anything else before I announce my findings?
Basically, I wish I could see my parole officer and apologize to her for my actions. You know.
Thank you. So I'm going to take a few moments to go over all the evidence presented as well as the testimony that I heard, and then I will announce my findings.
Yes, sir.
I will now notify you of my findings on probable cause. I make a finding of probable cause on charge number 1, reporting based on the evidence presented in State's Exhibits A and D. I make a finding of probable cause on charge number 2, GPS, based on the evidence presented in State's Exhibits A, D, E, F, G. I make a finding of probable cause on charge number 3, curfew, based on the evidence presented in State's Exhibits A, D, E, and G. I make a finding of probable cause on charge number 4, program participation, based on the evidence presented in State's Exhibits A and D. I make a finding of probable cause on charge number 5, drugs, based on the evidence presented in State's Exhibits A, D, and H. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. The records office at this facility, as well as your parole officer, will be notified. At the revocation hearing, myself or another hearing examiner will determine if you violate the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what sanctions should be imposed. This concludes the hearing for Ernesto Diaz Gonzalez, inmate number 161546. You're all set, sir. You'll be notified of when the revocation hearing is, okay?
All right. Thank you, sir.
You're welcome. Have a good day.
Thank you, sir.
Attorney Dean, are you all set?
Hi,
Attorney?
yes, I'm here. Hi, sorry about that. I'm here. A counselor from the jail just called me.
No worries. Do you have your video today or? I can't hear you.
Yes, it's all
Yeah.
working.
All right,
Yes.
thank you. We're gonna get started. That's awesome. Are you all set?
Thank you. Yep, I'm all set.
Okay. Good morning. I'm Parole Officer Menard, and I'm hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning William Askew, inmate number 209364. Today is July 30th, 2026. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
William Askew, 209364.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Can you please identify yourself for the record?
Yes, Hannah Dean for the record. And P.O. Menard, I wasn't sure. Do we need to wait until 10 a.m. to get started? Because of the docket?
I can double check that. So just,
I'm fine either way. I just didn't want there to be an issue if we went forward now.
I'm gonna double check that. So I'll be
Thank
right
you.
back, okay?
Thanks, I appreciate it.
No problem. We are just taking a brief recess for inmate, SKU inmate number 209364. Attorney Dean, we're gonna start at 10 o'clock, just so we're on the
Okay.
same schedule. So we'll be back
Perfect.
in a couple minutes, okay?
Perfect.
Sorry
Thank
about
you so
that.
much. No worries at all. Thank you.
What time is it?
We only got four minutes. We're gonna start in 4 minutes, okay?
All All right. Good morning, Attorney Dean.
Good morning. How are you doing, Mr. Askew?
You know, trying to stay wise and civilized.
Okay, it's 10 a.m. We're just going to restart. Okay. Good morning. I'm Parole Officer Renard, and I am a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning William Askew, inmate number 209364. Today is July 30th, 2026. This hearing is being conducted via video at the Board of Pardons of Parole Central Office and Robinson Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Yes, William Askew, 209-364.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Askew.
Thank you. This is a preliminary hearing which has three purposes under Connecticut law. One, to determine if there is probable cause to believe you committed an act that violated the conditions of your parole. B, to determine if the act is sufficiently serious to warrant the revocation of your parole. And C, to determine if you should be held in prison pending further proceedings. State, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Askew, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence that you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon felony of perjury.
I do.
Thank you. You can put your hand up. The procedure for this hearing, first I will read you your rights, then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
You have important rights at this hearing, which we will now review. You have the right to an attorney. Attorney Dean is present here today. You have the right to receive written notice of charges of violation. Did you receive written notice?
I did.
You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
I do, and yes, I am.
Okay. We will now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Charge number 1, condition of program participation. On March 26, 2026, you participated in an intake at Walmore. On March 26, 2026, for mental health and substance abuse. You were recommended for IOP, which started on March 31st, 2026. On April 8th, 2026, and April 9th, 2026, you signed out of Central Ave halfway house to attend the aforementioned appointments. Per Wellmore, you failed to attend treatment on April 8th, 2026 and April 9th, 2026. For charge number 2, obedience to the law. On July 9th, 2026, you were completing your intake at Chase Center halfway house. Upon your intake, staff found a pen, paraphernalia with its ink vial missing with white powder residue in your belongings. A UA was given to you, which you were positive for cocaine. Specimen was sent to Redwood Toxicology Laboratory, Inc., which confirmed positive for cocaine. You are in violation of your special parole conditions, which states, I will not use or have in my possession or control any illegal drug, narcotic, or drug paraphernalia, firearms, ammunition, or any other weapon. Charge number 3, drugs. On June 28th, 2026, you tested positive for cocaine. On July 9th, 2026, you tested positive for cocaine. Charge number 4, halfway house placement. On April 8th, 2026 and April 9th, 2026, you were given a pass from Central Ave halfway house to attend your IOP treatment at Wellmore. On April 8th, 2026, you signed out at 4:30 p.m. with a scheduled return time of 8:30 p.m. You arrived at 8:55 a.m. Arrived back at 8:55 a.m. On April 9th, 2026, you signed out at 4:30 p.m. with a scheduled return time of 8:30 p.m. You arrived back at 8:26 p.m. You failed to attend both your appointments, which would make you unaccountable for 8 hours and 51 minutes. You were in violation of halfway house agreement, which states I will only go to the locations indicated on the approved community pass unless changes have been authorized by staff. June 28th, 2026, Ren East gave you a community pass for church at 11 a.m. with a return time of 1 p.m. You failed to return at 1 p.m. You arrived back to Ren East at 3:52 p.m. You were given a UA test, which your specimen was positive for cocaine. You were unaccountable for 2 hours and 52 minutes. You were in violation of halfway house agreement, which states I will return to the halfway house from my community pass at my scheduled return time. If I am unable to do so, I will call the program staff to explain why I am expected to be late and receive a new return time. On July 6, 2026, you signed out of Ren East at 1:08 p.m. You attend an appointment at MCCA. You had a scheduled return time of 3:45 p.m. MCCA reported you couldn't render a urine, so your intake was incomplete. You were rescheduled for July 13th, 2026. After leaving MCCA, you also failed to return to the halfway house. Local hospitals and police departments were contacted to no avail. On July 7th, 2026, halfway house staff was able to confirm you arrived at the hospital on July 6th, 2026 at 11:21 p.m. This would make your whereabouts in the community unknown for 7 hours and 36 minutes. You were in violation of halfway house agreement, which states I will only go to the locations indicated on an approved community pass unless changes have been authorized by staff. I will return to the halfway house from my community pass at my scheduled return time. If I am unable to do so, I will call program staff to explain why I am expected to be late and to receive a new return time. On July 9th, 2026, upon entering Chase Center halfway house, you were found with paraphernalia in your possession that consisted of an empty pen with white powder residue. Halfway house conducted a UA on you, and your specimen results were positive for cocaine. Your results were sent to Redwood Toxicology Laboratory, Inc. Results confirmed positive for cocaine. The state has filed the following following exhibits pre-marked for identification purposes. Exhibit A, remand to actual custody. Exhibit B, parole conditions dated June 18th, 2026 and July 9th, 2026. Exhibit C, halfway house agreement dated on June 18th, 2026 and July 9th, 2026. Exhibit D, notice of parole violation. Exhibit E, notice of parolee rights. Exhibit F, parole violation report. Exhibit G, incident report dated June 28th, 2026, July 6th, 2026, and July 9th, 2026. Exhibit H, offender misconduct dated June 26th, 2026 times 2. Exhibit I, voluntary admission of positive test results for prohibited substances. Exhibit J, Redwood toxicology report. Exhibit K, email from Wellmore. Exhibit L, revocation hearing summary. And Exhibit M, pictures of paraphernalia. Attorney Dean, did you receive the notice of parole violation, parole violation report, and the other documents I just marked for identification purposes?
Yes, we have.
And were you able to review this information?
Yes.
No defense exhibits have been filed from parolee's counsel. Today we have no witnesses. Attorney Dean, do you request any witnesses?
Not today, thank you.
It is now the defense's opportunity to respond and to make a short statement, calling witnesses and testify with respect to probable cause and the severity of the allegations.
Yes, thank you very much. I would note as to charge one program participation, I would argue there should be a no finding. The allegations here predate my client's last special parole remand where he participated in the top program, and the conditions entered as evidence for this charge did not cover the period of time for these allegations. So based on that, I would argue there should be a no finding. As to the second charge, I would argue that there are no pending cases, and the conditions cited for that charge is related to drug and weapon possession. I would argue that the allegations don't meet the elements for the obedience to the law charge. I also do wish to put some information on the record concerning my client. And Mr. Askew, would you mind just explaining to the hearing examiner the situation concerning the pen that was found when you entered Chase Center? Can you explain the history there, the situation with Renaissance East and all of that, if you don't mind?
Yes, I can. On July 6th, as it states, I exited Renaissance East to go to MCCA. Subsequently, that same day, I went into Woodbury Hospital and was admitted. In the time I was admitted in the hospital, Renaissance East undergone a full, complete house shakedown where they was looking for contraband and whatever sorts. So all my belongings were still there as I left, as far as I know. Upon my release from my discharge from Waterbury Hospital, I was picked up, met downstairs by one of the monitors. His name is John. I don't know his last name. From Renaissance East, he was there waiting for me to take me to the new halfway house placement I was being placed in over there on 21 Cliff Street, Chase Center, with my belongings. Upon entering the Chase Center, I was told that I couldn't grab my belongings. I couldn't go through it. They had to go through it. So I was all right with that. I just wanted to know what I was missing and what I didn't have. They put my clothes in some kind of heating bag. I guess it's treated for bed bugs, to treat bed bugs. So 2 hours later, I was able to grab my clothing. I grabbed my clothing. So as I was sorting through my clothing, I'm noticing that there's a few clothing articles, several pieces of clothing articles that wasn't mine, and that I was missing some of my own clothing articles. So the clothing articles that wasn't mine, I brought them back up front to another staff member. Her name was Teresa. I don't know her last name either. And I asked her politely if she would call Renaissance East to let them know that I have some belongings some clothing items that don't belong to me, and that I'm missing clothing items, I'm missing cosmetics, and toiletries, utensils, personal items that I acquired over the time in these halfway houses. And her response to that was like, well, you guys know what it is when you leave and this and that, you don't return back, stuff gets missing, things get confused. So I said, well, what am I supposed to do? Can you just please call them? Or I could call them myself and let them know. So she said, well, you do that on your own. I said, what do you want me to do? She said, I said, what do you want to do with these clothes? She said, you can throw them away. I said, I'm not going to throw them away. I just leave them right here. And so I proceeded back to my designated area where I was assigned by my room and proceeded to put my stuff away. And then nothing else of it until I found out when Roll Officer Pearson came to the Hartford Correctional County to survey my violation papers. And after I was reading it, well, I didn't have a positive reaction when he first brought me the paperwork, so he didn't really go over with me. But when I got back to my unit, I'm reading it and I'm like, what the heck is this? So it's about the paraphernalia. So it's not mine, and I don't know.
Thank you.
Thank you.
I appreciate you putting that on the record, sir.
Yep.
As to the second charge, drugs, my client did not contest the alleged positive on 6/28. He did discuss this with parole. However, he indicates that the follow-up on 7/9 was likely residual and not due to new use. I would note, unfortunately, with the urinalysis we receive for these types of cases, it doesn't show us the levels from one test to the other. However, my client strongly believes that if it did show that, it would indicate that his levels went down drastically. My client does suffer, as is noted in the parole paperwork, from rhabdomyosis, which is a severe disease that impacts the kidneys, and he strongly feels that this could have led to the substance staying in his system for a longer period than the average person, because this does have an impact on his kidneys filtration process due to that specific disease. As to charge 4, I would renew the arguments made for charge 1 as to the allegations that predate this most recent release to parole. As to the allegations of the hospital, I will note that my office is trying to get those medical records, as my client indicates the information here is inaccurate. Mr. Askew, do you mind just explaining the situation of you going to the hospital and what transpired there for the parole hearing examiner, if you don't mind?
Yes. I got into Waterbury Hospital, I want to say around 4:20ish. I'm not sure. My phone had died down, but the charger I had don't work for the phone I got, so I didn't have. I maybe had limited power when I left the halfway house. So I would think it was around 4:20ish. I get into the hospital. I'm in bad situation. I'm in bad. I'm doing bad. I'm in pain. So instead of keeping me out in the lobby like they normally would do, I stayed in the lobby for about like 20 minutes. They brought me into the back to the nursing station, had me hooked up to DKG and all this stuff. They proceeded to put me to get me strapped up for the IVs and all that, because they know that they gonna. I needed some hydration fluids in me. I was in the hallway on the beds that they have out in the hallways. And then I was moved to a room right next to the hallway. And from there, things got to look like timing wise. I must have dozed off. I woke up with bad cramps. So like, I think a couple hours might have passed by. I woke up with cramps, and I woke up like, So when the nurse came through, it's like, is everything okay? Everything okay? I was like, when is somebody gonna see me, man? I need some type of muscle relaxers, this and that, I don't mean to say this, that, but I need muscle relaxers. I need to be seen. So she went to proceed to scan my wristband. She hit it once, boom, nothing happened. She hit it again, nothing happened. She's like, hold on 1 second. Something's not right. They come back probably like 7 minutes later. Oh man, I'm sorry about that. It was a mix-up. Like, what's the mix-up? Like, we accidentally discharged you because we thought it was you that walked out because there was another brother there, and he just got fed up and just like, I'm out of here, I'm going, boom, 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 and left. So when he was in the area where I once was, so I think he was there before me. So me not being in that same area where he was at, and I was moved into one of the rooms, I don't know what the confusion is. I don't know how I got confused as for him being me and me being him. They accidentally discharged me because I guess the barcode, what they were saying, didn't match. It was, I guess, whatever how the hospital does it, it didn't scan them or didn't register. So they had to, by this time, I don't know what time it was, they didn't send me back in the business room talking about, all right, date of birth, social security number, and they had to re-ban me. I don't know if it was a new shift or this and that, but I got re-banned. So when the halfway I was calling and found out, oh, yeah, well, it logged in at whatever time they said it was. But I clearly wasn't there at 11:21. And if you get hospital footage, I guess it'll show you.
Thank you very much. I appreciate that. So I would argue that based on those arguments, for the two charges I had mentioned, 1 and 2, there should be no findings. And then I would also just argue that the matters here are not serious enough to warrant revocation for my client. Thank you very much.
Thank you. I'm going to take a few moments to go over all the evidence as well as the testimony that I heard, and then I will announce my findings. I'm just going to take a brief recess, and I'll be right back with my findings. Okay.
Thank you.
Thank you.
Thank you.
Going off the record with inmate number 209364.
Where's she at? I got any paper towels somewhere. I should see all that tissues out. I broke my nose. That's some kind of got any tissue? Tissue. You have paper towels and tissue? They got me on a quick recess. Oh, Miss Wolf, I can violate because you got me absent. Off screen.
Mr. Askew, your volume's still on. I just wanted to let you know.
All right. Yeah, I want to reset. Attorney Dean, does it have any mention of what the parole officer or the reporting parole officer was recommending?
Yes, but that is for, if we get to a revocation hearing, the second hearing, that would be, that would come into play at that time. That's not for this hearing.
Another question, for my understanding, you solely work for the public defender's office, or do you have a private practice?
Just the public defender's office.
Uh,
Okay, we're gonna go back on the record. We are back on the record with inmate William Askew, inmate number 209364. I'm making no finding of probable cause on charge number 1, program participation, based on the predates and with the insufficient evidence presented. I make a finding of probable cause on charge number 2, obedience to the law, based on the evidence presented in states exhibits B, F, and G. I make a finding of probable cause on charge number 3, drugs, based on the evidence presented in states exhibits B, F, C, G, and H. I make a finding of probable cause on charge number 4, halfway house placement, for parts 2, 3, and 4, based on the evidence presented in states exhibits B, F, C, G, and H. And there's a no finding on part number 1, based on the predate and insufficient evidence. I find that the acts are serious enough to warrant revocation. I have also determined that you should be detained while you wait for your revocation hearing. The records office at this facility, as well as your parole officer, will be notified. At the revocation hearing, myself or the hearing examiner will determine if you violate the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what sanctions should be imposed.
Mr. Askew, I'll set up a call with you, as will my social worker, so we can try and get some of those records.
All right, thank you very much.
Thank you. I'll talk to you soon.
All right, you guys have a good day.
Thank you. Have a good day.
Good.
Thanks. Take care.
Thank you.
Hi.
Hi, good morning. How are you?
Good. How are you? Are you here for Santana?
Yes.
All right. Was the meeting supposed to start? He was here at 10 and we waited like half hour. I sent him back, but I can bring him back down.
Yes, please. Yeah, we had.
Yeah, it's gonna
yeah.
just be a few makes because he's in restrictive housing, so I gotta shut down the hallways for him to get here.
Okay. Thank
All
you.
right. You're welcome. Back, they just called in. Yeah, so, if we can get it. All right, thank you. Just have a seat, somebody's home. seat, mister. Hey, Mirage, don't open the hallways up because I have one leaving here going to RHU. So once he comes in, I'm just gonna swap him out with the other one, okay? That's all of them they need to, just leave them in the cups and then come back with a cup you need here. The payment is right. Probably that Leonardo. Oh, Alexander. Oh, yeah, I think he went on a trip. He's right here.
Oh.
I have no idea, but let me call you right back, okay? He's awesome.
Right.
All right. Just. Hi, how are you? Oh, beautiful. I will be out there in a few. Or go grab it. All right.
Attorney Jones, are you all set?
Yes, I am.
All right, we're going to begin. Good morning. I am Parole Officer Menard, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Felix Santana, inmate number 408441. Today is Thursday, July 30th, 2026. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Hartford Correctional Center. Please state your full name and DOC inmate number for the record.
Felix Santana, 408441.
Thank you. This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Attorney Jones. Can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones on behalf of Mr. Santana.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Santana, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon felony of perjury?
Yes, sir.
You're all set. You can put your hand up. We're going to go over the procedure for the hearing. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, sir.
We're going to go over your rights. You have the right to be represented by an attorney and at this hearing, and counsel is present. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes, sir.
Okay. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, sir.
We will now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Charge number 1, obedience to the law. On April 9th, 2026, a judge at GA 14 signed off on a warrant for your arrest for violating Connecticut General Statute 53A-32, violation of probation. Based on the warrant, you had a court-ordered condition not allowing you to possess a device that could access the internet. On March 25th, 2026, you were found by Halfway House staff to be in possession of a cellular phone that had internet connectability. This device had not been approved by your parole officer or your probation officer. On April 16th, 2026, you were served with a probation warrant and were taken into custody. The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, parole conditions, Exhibit B, notice of parole violation, Exhibit C, parole violation report, Exhibit D, remand to custody order, Exhibit E, adult probation arrest affidavit, Exhibit F, photo of cell phone found on Santana on March 25th, 2026. In addition, the states filed an addendum to the parole violation report that states, on June 17th, 2026, Mr. Santana appeared before the court at GA 14 under docket number H14H-CR22-0752228-S for the charge of violation of probation 53A-32. He was sentenced to 34 months execution, suspended after 8 months jail, and probation, 6 years of probation. Attorney Jones, did you receive the notice of parole violation report, and other documents I just marked for identification purposes?
Yes.
The defense has filed the following exhibits, which are marked Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Attorney Jones, do you have any witnesses today?
No.
It is now the defense's opportunity to call any witnesses, present evidence, and to speak on any evidence submitted.
Thank you. In regards to the only charge 1, obedience to the law, it is our position that this charge of violation of probation is not appropriately charged under the obedience to the law section. The violation of probation that was pending in court is not new criminal conduct. It's a violation of a condition of his release that was court ordered. So therefore, we would submit that there's insufficient evidence to support a finding on the charge. However, I would just note that the addendum is stated accurately in regards to the disposition. He does have an end of sentence date, I believe that to be December of 2026, and I'm not certain of the exact date, and perhaps you can confirm that.
His end of sentence date?
Correct, on the 8-month court sentence on the violation of probation.
That's December 16th, 2026.
Okay. All right, thank you. That is all in regards to the charge. We would like to be heard on his background and history at the appropriate time.
Okay, thank you. I'll now take a moment to review the case and will notify you of my findings in a moment. For charge number 1, I find that you violate a condition of obedience to the law based on the evidence presented in State's Exhibits A, C, E, and F. That concludes the fact-finding portion of this hearing. You'll now have the opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine the outcome I will recommend. Attorney Jones, do you wish to make a statement regarding the violation background and history at this time?
Yes, thank you. My client is 43 years of age. He's single. He does have 6 children. His primary support in the community is his oldest son, Demetrius, who is 21 years of age. He was mostly raised in the New York area. He attended schools in Brooklyn, New York. He does have an 8th grade education and was a special education student. He was in the community during this period of supervision, having first been released to supervision on January 16th of 2026. And he was in the community for approximately 3 months. During that time period, he was residing at the Eddy Center Halfway House program located in Middletown, and he remained at that location until he was remanded into custody. During the time that he was on supervision, during that 3-month period, he was participating in the Connection Center for Treatment of Problem Sexual Behavior programming. He was scheduled to begin intensive outpatient programming and trauma groups at Rushford, also located in Middletown. He does have a previous treatment history of that includes successfully completing an IOP at Rushford, as well as engaging with community renewal team in Hartford. He was gainfully employed working at Taco Bell located in Middletown as well. Upon reinstatement to supervision, he's asking to be placed in a halfway house in the Hartford area, but specifically to return to the Eddy Center in Middletown, which I know is part of the Hartford area for halfway houses. He does have his employment to return to at Taco Bell. He's interested in doing that on a part-time basis, as he would like to apply for disability for mental health purposes. By way of treatment, he's open and amenable to all treatment recommendations, and that's including re-engaging with the Connection Center for Treatment of Problem Sexual Behavior. His parole officer in the recommendation was asking for a sanction of 4 months. He did receive that 8-month court sentence on the violation of probation, so we would be asking for a sanction that does not exceed the December 16, 2026 EOS date on his court sentence. Mr. Santana, is there anything that you would like to add?
No, I would just like to go back to the community, keep doing the things that I was doing. I was doing good. I just made a mistake, so
Thank you.
Okay, thank you. Anything else, Attorney Jones?
No, nothing further.
I've listened to testimony and reviewed all the evidence provided. Based on that, I recommend that your special parole be revoked with a new re-parole date of December 16th, 2026. This is an approximate 8-month sanction. This sanction is calculated from the date you were remanded to custody. The following conditions are recommended for your parole release: halfway house, no alcohol beverage consumption, no contacts with victims, One Direction, 310 Franklin Ave, Hartford, Connecticut, mental health treatment, no contact with minors, and problem sexual behavior treatment. My findings and recommendations will be forwarded to the board on August 13th, 2026. You should receive the official written decision from the board within a week from that date. The board may lessen the recommended sanction or let my recommended sanction stand. If the board decides to impose a sanction longer than what I've recommended, then a supplemental hearing will be held. Before the hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. During the supplemental hearing, you'll have an opportunity to respond to those specific reasons while in front of a panel of the board. This concludes the revocation hearing. I am now going off the record.
Felix, if you want to contact me after the August 13th board review date, I can let you know if the board accepted the recommendation, okay?
All right, so what was the sentence again, if you don't mind me asking?
So it's going to run with your court sentence if it's accepted, and that means that
Alright.
you would be released back to supervision on December 16th of 2026.
All right, so call you after, see what they said?
After August 13th,
Okay, no problem.
okay? That's when the board is going to look at your case, okay?
All right, no problem.
Okay.
Thank you.
All right, you're welcome, Felix. Good luck.
Thank you. You're all set.
Thank you.
guess you can't tell from the screen. Hi, this is Judge Gibson. Is our Spanish interpreter with us? Can you offer his contact information, please? Can you mute, please? This is Judge Gibson. Do we have our Spanish interpreter with us?
Yes, Your Honor. For the record, Vanessa Beglini, staff interpreter.
All right, please raise your right hand. Do you swear or affirm that you will truly and correctly translate English into Spanish and Spanish into English here today?
I do.
Good afternoon. This is Judge Gibson, and this is your first appearance hearing.
Buenas tardes. Esta es la juez Gibson y esta es su audiencia de primera comparecencia.
I was just going to read it all the way through, and then I know you have the scripts, and see if the Spanish interpreter could do it after.
Yes, Your Honor. Thank you.
Thank you. A first appearance hearing has 4 purposes and 4 purposes only. First, I will advise you of the charges that have been filed against you. Second, I will ask if you have an attorney representing you. If you've hired counsel and they are present, they will speak on your behalf. If your attorney is not present, you will have the option of proceeding forward with your hearing today or postponing it until tomorrow. If you postpone the hearing, it is your responsibility to contact your attorney and let them know you will have court. No one else will do that for you. If you wish to move forward without your attorney present, we can do that. If you do not have an attorney, I will ask if you can afford one. If so, we will make note of that and move on. If not, and you qualify, I can provisionally appoint the Office of the Public Defender to represent you, pending you filling out an application. You have a right to have your attorney present before and during any questioning. Third, if there are any challenges to probable cause, I will address those. Finally, I will review your bonds and/or other release conditions with you to determine if any changes are necessary. Be aware if this court places you on pretrial release today, regardless of whether it is straight pretrial release or a condition of your bond, the conditions announced in court today go into effect immediately, meaning even while you remain in custody. So if you are given a no contact order, it is in effect immediately. Throughout this entire process, you have a constitutional right to remain silent. If you choose not to remain silent, anything you say can be used against you. Everything that is being said where I am located, as well as where all of you are located, is being recorded. There is an assistant state attorney present listening to everything that's being said, so do not say anything about the crime itself. Please keep these rights in mind as we go through the process, and please step forward when your name is called.
Una audiencia de primera comparecencia tiene 4 propósitos y solamente 4 propósitos. Primero, se le informará de los cargos presentados en su contra. Segundo, le preguntaré si ya tiene un abogado que le está representando. Si ya contrató un abogado y este se encuentra presente, él o ella hablará a nombre suyo. Si su abogado no está presente, usted tendrá la opción de proceder con su audiencia de hoy o posponerla hasta mañana. Es responsabilidad suya contactar a su abogado para avisarles que tendrá una audiencia. Nadie más hará eso por usted. Si desea proceder sin la presencia de su abogado, lo podremos hacer. Si no tiene un abogado, le preguntaré si puede pagar uno. De ser así, tomaremos nota de eso y procederemos. Si no y califica, se le puede nombrar provisionalmente la oficina del defensor público para que le represente en espera de que usted rellene la solicitud. Tiene derecho a que su abogado esté presente antes y durante cualquier interrogatorio. Tercero, si hay desafíos o retos ante el motivo fundado, los abordaré también. Y por último, revisaré sus fianzas y otras condiciones de liberación con usted para determinar si es necesario algún cambio. Por favor, sepa que si la juez lo coloca hoy bajo libertad condicional, sin importar de si es como condición de fianza o no, las condiciones que se anuncian hoy en esta audiencia entran en efecto inmediatamente. O sea, aún usted se encuentre encarcelado, por ejemplo, si le dan una orden de no contacto. Esa orden entra en efecto inmediatamente. Mediante todo este proceso, usted tiene el derecho constitucional de permanecer callado. Si escoge no permanecer callado, cualquier cosa que diga se podrá usar en su contra. Todo lo que se está diciendo aquí y donde yo estoy ubicada y donde está ubicado usted está siendo grabado. También hay un asistente de la fiscalía presente quien está escuchando todo lo que se dice, así que no diga nada sobre el delito en sí. Por favor, recuerde sus derechos mientras pasamos por este proceso y pase al frente cuando se llame su nombre. Thank you, Your Honor.
Yes, ma'am. All right, we're going to first take the cases requiring the assistance, that require the assistance of the interpreter, then we'll do the private attorney cases, and then we'll handle the remainder of the docket. The first case is Dania Chamizo.
Bien, nos ocuparemos de los casos que necesitan asistencia de la intérprete, luego se hablará de los casos de abogados privados y luego el resto. Dania Camiso, pasar al frente, por favor.
Ma'am, you're here because it looks like the state filed an information changing the name on this case, and you're charged with felony retail theft.
Señora, usted está aquí porque parece que la fiscalía presentó un informe donde cambiaban el nombre en este caso y a usted se le acusa de hurto grave de tiendas minoristas.
Does Ms. Chamizo already have counsel appointed on this case?
Pregunto al personal si la señora Cumiso ya tiene un abogado nombrado en este caso.
No.
No.
The clerk's just confirming.
La secretaría está confirmando.
Ma'am, would you like for me to appoint the public defender to represent you, or are you going to hire your own attorney or represent yourself?
Señora, ¿desea usted que yo le nombre un defensor público para que la represente o usted va a contratar un abogado privado o usted misma se va a representar?
Deseo un abogado público.
I would like a public attorney.
I provisionally appoint the public defender's office to represent you in this case.
Le nombro provisionalmente la oficina de los defensores públicos para que la representen en ese caso.
I have reviewed the capias, the information, and the complaint affidavit. I do find probable cause for the charge.
He revisado la orden de aprehensión, el informe acusatorio y el affidavit de la demanda. Determino que existe motivo fundado para el cargo.
In this case, I'm going to require a bond in the amount of $5,000.
En este caso, exigiré una fianza de $5,000.
A condition of that bond is that you have no contact with Ulta Beauty Stores.
Una condición de esa fianza es que usted no podrá tener ninguna clase de contacto y comunicación con las tiendas Ulta Beauty.
Additionally, that you stay at least 500 feet away from the event location from this case.
y además que se mantenga como mínimo a 500 pies de distancia del lugar del evento en este caso.
You have an arraignment hearing set for August the 18th at 8:15 a.m. in the A2 Division.
Y usted tiene una audiencia de instrucción formal de cargos para el 18 de agosto a las 8:15 a.m. en la división A2.
Thank you.
Gracias.
The next case is Jonathan Coriano. You ready for me to say it?
It's not letting me.
Hold on one second, we're having a technical issue.
Un momento, tenemos un fallo técnico.
Can you try again? Sorry.
That's all right, it happens. All right, so you're charged with you have a warrant out of Osceola County for battery and criminal mischief under $1,000.
Señor, tiene una orden de detención del condado de Osceola por agresión física y daño a propiedades menos de $1,000.
Because it's from another county, I cannot appoint a Polk public defender to represent you.
Ya que es de un condado externo, no le puedo nombrar un defensor público del condado de Polk para representarlo.
All right. I have reviewed the arrest report and the warrant confirmation teletype. I do find probable cause for the charges.
Bien, he revisado el informe de arresto y la orden de arresto, la confirmación mediante el instrumento teletype y existe motivo fundado para los cargos.
Osceola County has set your bond status as no bond on the domestic violence battery charge.
El condado de Osceola fijó su estatus de fianza en no fianza en cuanto al cargo de violencia intrafamiliar, agresión física.
On the criminal mischief charge, Osceola County has set your bond status at $500.
Por el cargo de daño a propiedades, el condado de Osceola ha fijado su estatus de fianza en $500.
Osceola County is requiring the following conditions for that bond.
I'm sorry, Your Honor, could you repeat that for the interpreter?
Yes, Osceola County is requiring the following conditions for that bond.
El condado de Osceola exige las siguientes condiciones para esa fianza.
Do not return to 1317 Royal Street.
No regrese a 1317 Royal Street.
That is the sum of the address they provided.
Esa es la suma de la dirección que proporcionaron.
Osceola County is also requiring no contact, and I'm going to spell the name
El
with
condado,
capital I-L-I-A-S-K-A is the first name. And then the middle name, go ahead.
el condado de Osceola, señor, exige que usted no tenga ningún contacto ni comunicación con la siguiente persona y voy a deletrear el nombre. I-L-I-A-S-K-A.
The middle name is C-O-L-L-A-Z-O.
El segundo nombre es C-O-L-L-A-Z-O.
And the last name is C-O-R-I-A-N-O.
Y el apellido es C-O-R-I-A-N-O.
If Osceola County has not come to pick you up and you're still in our custody on August the 6th, then you'll be brought back to first appearance here.
Si el condado de Osceola no ha venido a buscarlo y sigue detenido en nuestro centro, el 6 de agosto lo traerán nuevamente a primera comparecencia aquí.
Thank you.
Gracias.
The next case is Daniel Hernandez Mestre.
Daniel
Buenas
Hernández
tardes.
Mastre.
All right, please announce your appearance.
Richard McKendrick, with Mr. Daniel Alexander Hernandez Maestre.
Se presenta el abogado Richard McKendrick representando al señor Daniel Alexander Maestre.
Sir, your counsel is present in the courtroom with me.
Señor, su abogado está presente en la sala conmigo.
And
Okay.
you've been charged with resisting an officer with violence.
A usted se le acusa de resistencia a un oficial con violencia.
Additionally, pretrial services notes that you have an open case number 2026 MM 2196.
Adicionalmente, el Servicio de Libertad Previa al Juicio hace constar que usted tiene un caso abierto bajo el número 2026 MM 2196.
What would you like to tell me?
Your Honor,
Abogado.
yes, this is a limited notice of appearance. These charges all occurred at the same time, the 2026 misdemeanor case, and this one, they added these charges later on, but it occurred out of the same incident, Your Honor. So, in addition, my client was in treatment and got out, I think.
Su
yesterday.
señoría, esta es una comparecencia limitada por el abogado. Estos cargos, su señoría, ocurrieron a la misma vez en el caso de delito menor de 2026 y agregaron otros cargos más adelante, pero todo ocurrió durante el mismo incidente, su señoría. Adicionalmente, mi cliente estaba bajo tratamiento y salió, creo que fue ayer.
He then turned himself in, knowing that these charges were outstanding.
Y él mismo se entregó después, sabiendo que tenía estos cargos pendientes.
The one thing I saw that was a bit curious is that normally when a direct information is filed and the KPS is issued, it'll say, on certain charges, it'll say no bond until first appearance hearing.
Una cosa que vi que era un poco curiosa es que normalmente cuando hay un informe acusatorio directo que se archiva y que se emite una orden de captura, indicará en ciertos cargos que no hay fianza hasta la audiencia de primera comparecencia.
But this one just says no bond, and it's an F3.
Y este solamente dice no fianza y es delito grave en tercer grado.
I understand that, Your Honor, but I think that should be looked at as, these are in addition to the previous charges. And the fact that he has turned himself in shows that he's not a flight risk, that he's done everything that he's needed to. His family's been in contact with me ever since. I've known that this was out there.
Okay. Comprendo, su señoría, pero pienso que esto debería verse, como usted sabe, son en adición a los cargos anteriores y juntamente al hecho de que él se entregó, muestra que él no representa un riesgo de fuga y que él ha hecho todo lo que necesitaba hacer y su familia ha estado en contacto conmigo desde que yo he sabido que esto estaba pendiente.
I've been in contact with Detective Walsh on this case since April, trying to see what's going on with the case.
He estado en contacto con Detective Walsh, en este caso desde abril, tratando de averiguar lo que pasa con este caso.
And my office also contacted Detective Walsh yesterday, the day before, when we found out he was coming out, to know exactly what she wanted us to do.
Y mi oficina también contactó a Detective Walsh ayer o el día antes, cuando se sabía que él venía para saber exactamente lo que ella quería que hiciéramos.
So I'd ask that a reasonable bond be set in this case. I'd almost ask that without, but knowing the court probably wouldn't do that. But all these charges happen at the same time. He was in treatment, he's out, and he's been wise.
Señora juez, pediría entonces yo que se fije una fianza razonable en este caso. Casi pediría sin fianza, pero sabiendo probablemente que la juez no haría eso. Pero estos cargos ocurrieron a la misma vez, él estaba bajo tratamiento y se ha comportado sabiamente.
Let me ask the state, is that no bond just a typo, or was that a meaningful no bond?
Fiscal, le pregunto, fiscal, ¿este anuncio de no fianza fue un error tipográfico o era en verdad no fianza?
Full candor to the court, Your Honor.
Con sinceridad completa ante la juez.
I have no information one way or the other.
No sé cuál de las dos aplica en este caso, señora juez.
The reason I ask the questions, of course, is because it's a capias, as you all know, is different than an arrest warrant. Arrest warrant, I have discretion. Capias is, in some circumstances, if they are issued by a judge, then I have no discretion. These are the ones that are filed when the state attorney's office files a direct information. So I guess I would start with asking the parties, what's my legal authority to alter the no bond?
Entonces, hago esta pregunta naturalmente porque si es una orden de captura, como ustedes saben, eso es diferente a una orden de arresto. Yo tengo criterio en cuanto a las órdenes de capturas en ciertas circunstancias. Si las emite un juez y yo no tengo criterio, estas son las que interpone la oficina de la Fiscalía cuando interpone informes de acusatorios directos. Así que supongo que le preguntaría a las partes, ¿cuál es mi autoridad legal para alterar o modificar el no fianza?
Because I will tell you, I think my opinion is I don't think I have the authority to alter it, although I think it is a typo.
Pero les diré que yo pienso, en mi opinión, yo no creo que tengo la autoridad de modificarlo, aunque creo que es un error tipográfico.
I didn't come forward with that argument to present today, but my opinion is that if this was issued by the state attorney's office, that at the initial hearing, the judge who has the authority over these matters, it's not set by another judge, has the authority this time to review things and make a reasonable decision based on the circumstances in front of the court.
Yo no presenté ese argumento el día de hoy, pero mi opinión es que esto se emitió por la oficina de la Fiscalía en la audiencia inicial y el juez, quien tiene la autoridad sobre estas causas, si no está fijado por otro juez, tiene la autoridad para hacer esto al tiempo de que se tome una decisión razonable basada en las circunstancias ante la juez.
I certainly agree with your logic. However, when I look at the bottom of the capias, and I have always found this language perplexing, but it says authorized by and/or FS 93248/ case assigned to Judge Gerald Hill, and it asserts the judge's name. So I am not sure if Judge Hill approved that or did not approve that.
Estoy de acuerdo con su lógica, abogado. Sin embargo, cuando miro a los montos de la orden de captura, siempre he encontrado este lenguaje un poco complejo, pero dice que está autorizada por FS 93248 / caso asignado a juez Gerald Hill y indica el juez del nombre. Así que no estoy segura si él aprobará o no aprobará de esto.
Hence the legal quandary we find ourselves in.
Por eso nos encontramos en un dilema legal en este momento.
I would suggest that we bring him back tomorrow, and that gives the state and the defense time to contact whoever they need to contact to find out if that is a typo. If I think it is, but again, I don't know.
Entonces, mi sugerencia sería traer al acusado nuevamente mañana para darle tiempo a la Fiscalía y a la defensa de contactar a quien deben ellos contactar para averiguar si eso es un error tipográfico o no. Yo pienso que lo es.
I've got 932.48 here. I can read it to the court.
Tengo aquí 932.48, se lo puedo leer a la juez.
And I'm certainly open to hearing it. I'm just telling you, I'm looking at the face of the capias and, you know.
Y estoy dispuesta a escucharlo, pero le digo, tengo que enfrentarme a la orden de captura, como usted sabe.
Upon the filing of an information, the clerk of the circuit court shall docket the information.
Al tramitarse un informe acusatorio, el secretario del circuito judicial debe incluir al listado de casos el informe.
And shall, without leave or order the court first being had and obtained, issue a capias for the rest of the person charged.
Y debe, sin ausencia o orden del juez, quien lo tuvo primero y lo obtuvo, emitir una orden de captura por el resto de la persona que está acusada.
And the clerk shall likewise issue any and all other necessary process incident to the information.
Y la Secretaría Judicial debe de la misma manera emitir cualquiera y todo otro proceso necesario al incidente del informe acusatorio.
That's it.
What does it say?
Fiscal.
Your Honor, I think bringing this case back tomorrow just to ensure that we are making an accurate representation of what's going on here. I don't know.
Señora juez, pienso que deberíamos postergar el caso hasta mañana para asegurarnos que estemos presentando las representaciones correctas sobre lo que está pasando aquí, porque no estoy seguro.
Let's put that one slide to the side because it may be sort of a moot point. Let's talk about his open case.
Ok, vamos a apartar eso por un momento porque quizás podría ser un punto nulo. Hablemos ahora del caso que él tiene abierto.
And state would request a Parker hold on case MM262196.
Y la Fiscalía solicita una detención bajo la ley de Parker por caso MM262196.
May I approach, Your Honor?
You may.
Thank you.
¿Me puedo acercar, señora juez? Sí, acérquese.
This is the amended affidavit.
Este es el affidavit enmendado.
The first affidavit did not have the felony as part of it, it just had the 3 misdemeanor cases, and that's the 2026 misdemeanor case that was filed previously.
El primer affidavit no tenía el delito grave incluido, solo tenía los 3 delitos menores, y ese es el caso de delito menor que se había tramitado previamente.
Are you saying that this is part of the 2026 MM2196?
¿Dice usted que esto es parte del caso 2026 MM2196?
It is all part of the same incident. The felony was added later, which became the new felony charge, but they're all, I'm hoping the state at some point will put them all with the felony case. But it shouldn't be Parker because it's all the same incident.
Es todo parte del mismo incidente. El delito grave se agregó más tarde y se convirtió en el nuevo cargo de delito grave, pero todos están, y espero que la Fiscalía en algún momento los pondrá todos con el caso de delito grave, pero no debería ser bajo Parker porque es todo el mismo incidente.
Whoever's talking needs to stop talking and mute your microphone.
Okay, let me show you.
Hold on a minute. Can you see who that is? Or did you mute him?
I disabled their mic.
All right, thank you.
So I just called the clerk who issued that KPS. It is no bond until first appearance. I'm going in the warrants tab and she said it should say that in the warrants tab as well.
Okay, I'm just saying it doesn't say that. Are you saying she's saying it's what it should
It's
have
supposed
said?
to be, and I'm about to look into showcase to
All
make
right,
sure.
the problem is that's not what it says.
Yes, ma'am.
Acabo de llamar a la secretaria quien emitió la orden de captura y dice que es no fianza hasta primera comparecencia. Estoy mirando aquí la orden de arresto y dice que debería decir que la orden de decir eso también en la orden de arresto. La jueza ha dicho que no dice eso. ¿Está usted diciendo que eso es lo que debió haber dicho? Correcto, sí. El problema es que ahora dice esto.
Could change what we're doing here if she made a mistake.
Right. If you're talking to a clerk who's saying that they made a mistake and they're going to issue an amended KPS now, then that would change what happens here today.
Sí, la señora secretaria está hablando con una secretaria quien dijo que cometió un error y que van a emitir uno enmendado ahora. Eso cambiaría lo que haremos aquí hoy.
Okay, you're showing me a document that's not the document I have. So you're showing me another document, but that again is not what got issued. I fully think it's a mistake, but until that mistake is clarified, it's a problem. So I'm going to let y'all do what you're doing right now. Let's go back to the question I was on, which was the Parker, and then we have many more hearings to get through. All right, so the defense is saying that this was not Parker eligible because this is all the same transaction. That's what it says the state.
Entonces, el documento que la señorita le estaba mostrando a la juez no es el documento que la juez tiene. Es diferente. Por lo tanto, aunque la juez cree que es un error, aunque ese error hasta que ese error se aclare, esto va a ser un problema. Ahora vamos a hablar de lo que está pasando en este momento. En la pregunta que estábamos hablando era que la elegibilidad de Parker. La defensa dice que no debería ser elegible para Parker porque todo es el mismo incidente. Fiscalía, ¿qué dice?
In other words, that the timing would prevent from his bond being revoked in the open case.
En otras palabras, que la línea temporal impediría que les revoquen la fianza en el caso que está abierto.
What says the state?
Fiscal.
Based on the two informations that I have in front of me, Your Honor.
Señoría, basándome en los dos informes acusatorios que tengo,
Looking at the open misdemeanor and the now filed felony.
mirando al caso de delito menor abierto y el delito grave que se ha tramitado ahora,
Show the misdemeanor with a incident date of March 19th, 2026.
se muestra un delito menor con un episodio de fecha marzo 19 de 2026.
And just pause there. When you say the misdemeanor, do you mean from 2026 MM 2196?
Fiscal, pause. Cuando usted dice delito menor, ¿se refiere al 2026 MM 2196?
Yes, Your Honor.
Okay.
Sí, su señoría.
And on the felony case CF 26-574-4.
Y en el delito grave CF 26-5744,
Which is this case?
es este caso,
I show an incident date of March 21st, 2026.
se ve la fecha de duplicación del una fecha de episodio de marzo 21, 2026.
But was he out on bond or was he out on pretrial release on March 21st?
¿Estaba él libre bajo fianza o estaba él libre bajo libertad condicional el marzo 21?
No, these all happened in the jail.
Todo esto pasó en la cárcel.
Is there a pretrial order or anything?
¿Hay alguna orden de libertad previa al juicio o libertad condicional o algo así?
Obviously, we've got a couple things going on with this case, and we've got about 59 people behind it. So we're going to bring him back tomorrow on both the open case and this case, and that should give the clerk time, if it truly was a typo, to correct it. I'll be here tomorrow, so I'll remember all of this.
Okay, thank you, Your Honor.
And I'm sorry for the inconvenience, but it's better to get both of these right.
Obviamente hay varias cosas que están ocurriendo en este caso y hay 59 personas más en el listado. Así que lo volveremos a traer mañana en ambos, el caso abierto y el otro caso, para darle tiempo a la Secretaría de que si es un error tipográfico lo corrijan. La misma jueza estará aquí mañana, así que ya se recordará todo esto. Gracias y disculpen el inconveniente, pero hay que hacer que ambos estén correctos.
All right, so Mr. Hernandez and Master, we'll all see you tomorrow, okay? Sorry for the inconvenience.
Ok, señor Hernández y Masteri, lo veremos mañana.
Okay. Just briefly, my apologies to the interpreter for speaking so fast. She's doing an excellent job.
Because I likewise apologize because I forget to pause too. Thank you so much. We'll see you tomorrow. Sorry about the confusion. All right,
Gracias, señor.
let's go into Antonio Hernandez Contreras. Sir, you're charged with possession or use of drug paraphernalia as an unauthorized alien.
Señor, se le acusa de tenencia o uso de parafernalia para narcóticos como extranjero indocumentado.
In possession of methamphetamine as an unauthorized alien.
Y tenencia de metanfetamina como extranjero indocumentado.
Would you like for me going to appoint the public defender's office to represent you, or are you going to hire your own attorney or represent yourself?
¿Desea usted que le asigne la oficina de abogados públicos? ¿Ya tiene usted un abogado privado o particular, o usted va a representarse a sí mismo?
Sí mismo.
The interpreter needs repetition. La intérprete necesita que repita su respuesta.
Así es mismo. Sí.
Self-represented.
Okay, and you understand that I could appoint the public defender to represent you if you wish.
Y usted comprende que la juez podría nombrarle la oficina del defensor público para representarlo si usted lo quisiera.
Sí.
Yes.
But you don't want me to do that?
Pero usted no quiere que la juez haga eso.
No, ¿cómo es eso? ¿Cómo es eso, amiga? ¿Cómo es eso, representante?
No, what do you mean? What is that? What do you mean by
No.
public defender?
Okay.
No,
It's
no
a court.
defender.
All right, stop talking.
Para de hablar.
It's a court-appointed attorney who can represent you, and since you're in custody, I would provisionally appoint them to represent you, if you would like. Is that what you want me to do?
Es un abogado asignado en el tribunal que lo podría representar. Y como usted está detenido, yo podría nombrárselo provisionalmente si usted lo pidiera. ¿Es eso lo que usted quiere?
It's the part it's the part I explained in the speech I gave at the beginning of when we came on to court.
Esa es la parte que expliqué al comienzo, en el discurso, al comienzo de la sesión de hoy.
All right, I heard yes before I gave that further explanation. So I provisionally appoint the Office of the Public Defender to represent Mr. Hernandez and Contreras at this time.
Escuché un sí antes de dar la explicación profundizada, así que provisionalmente le nombraré la oficina del defensor público para que represente al señor Hernández y Contreras en este momento.
I have reviewed the arrest report. I do find probable cause for the charges.
He revisado el informe de arresto. Determino que existe motivo fundado para los cargos.
In this case, I'm going to require pretrial release with bail as condition of pretrial release.
En este caso, exigiré libertad condicional con fianza como condición de la libertad condicional.
In this case, your bail is set at $6,000 on the possession of methamphetamine as an unauthorized alien charge.
En este caso, su fianza se fija en $6,000 por la tenencia de metanfetamina como extranjero indocumentado.
And $2,000 on the possession of drug paraphernalia as an unauthorized alien charge.
Y $2,000 por el cargo de parafernalia para drogas como extranjero indocumentado.
Once you're released, you must report immediately to Pretrial Release Services Office in person in Bartow.
Una vez que lo pongan en libertad, debe reportarse inmediatamente a la Oficina de Servicios de Libertad Condicional personalmente en Bartow.
At 1745 South Highway 17.
Ubicada en la 1745 South Highway 17.
Thereafter, you must report by phone every week, twice a week on Tuesdays and Thursdays.
Después tendrá que reportarse telefónicamente cada semana, 2 veces a la semana, los martes y los jueves.
You must submit to random urinalysis that you're required to pay for.
Tendrá que someterse a análisis de orinas aleatorias que usted tendrá que pagar.
You have an arraignment hearing set for September the 1st at 8:15 a.m. in the A2 Division.
Tiene una audiencia de instrucción formal de cargos el 1 de septiembre, 8:15 a.m., División A2.
And the court finds that the defendant is subject to an immigration detainer.
La juez determina que el acusado está sujeto a una detención migratoria.
Thank you.
Gracias.
Okay.
The next case is Manuel Nieves. All right, so you're charged with 3 counts of violation of probation from Polk County case number 2025 CF 010218.
Señor, se le acusa de 3 cargos de incumplimiento de probatoria del caso del condado de Polk 2025 CF 010218.
Would you like for me to appoint the public defender to represent you, or are you going to hire your own attorney or represent yourself?
¿Desea usted que le asigne la oficina de defensores públicos para representarlo? ¿Usted va a contratar un abogado privado por su cuenta o va usted a representarse a sí mismo?
Quiero un abogado.
I want a lawyer.
All right, are you asking me to appoint the public defender's office to represent you?
¿Está usted pidiéndole a la juez que la nombre a la oficina del defensor público?
Por favor.
Please.
I provisionally appoint the public defender's office to represent you in this case.
Provisionalmente le asigno la oficina del defensor público en su caso.
I have reviewed the arrest report. I do find probable cause for all the charges.
Tras revisar el informe de arresto, existe motivo fundado por todos los cargos.
Because they are VOPs, your bond status at this time is no bond.
Ya que son incumplimientos de probatoria, el estatus de su fianza es no fianza.
You have an arraignment hearing set on this matter on August the 25th at 8:30 a.m. in the F7 Division.
Tiene una audiencia de instrucción formal de cargos en esta causa para el 25 de agosto a las 8:30 de la mañana en la división F7.
Thank you, sir.
Gracias, señor.
Thank you.
The next case is Juan Manuel Rivera Guillermo. Sir, you are charged with resisting or obstructing an officer without violence.
Señor, se le acusa de resistencia u obstrucción a un oficial sin violencia.
Would you like for me to appoint the public defender's office to represent you?
¿Desea usted que le asigne la oficina del defensor público para que lo represente?
Or are you going to hire your own attorney or represent yourself?
¿Contratará usted un abogado privado o quiere usted representarse a sí mismo?
Privado.
Private.
All right, the clerk will note down that you are going to hire your own attorney.
La secretaría anotará que usted contratará su propio abogado.
Sí.
Yes.
I have reviewed the arrest report. I do find probable cause for the charge.
Tras revisar el informe de arresto, existe motivo fundado para el cargo.
In this case, I'm going to require pretrial release with bail as condition of pretrial release.
En este caso, exigiré libertad condicional, confianza como condición de su libertad condicional.
Your bail is set at $1,000.
Se establece su fianza en $1,000.
Once you are released, you must report immediately to pretrial release services office in person in Bartow.
Una vez que lo dejen en libertad, debe reportarse personalmente, inmediatamente, a la oficina de servicios de libertad condicional ubicada en Bartow.
At 1745 South Highway 17.
En la 1745 South Highway 17.
Thereafter, you must report by phone every week, twice a week on Tuesdays and Thursdays.
Después tendrá que reportarse telefónicamente cada semana, 2 veces por semana, los martes y jueves.
You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives.
Se le prohíbe usar, poseer o portar armas de fuego, pistolas, cualquier clase de arma, municiones, armas blancas o cuchillos.
You have an arraignment hearing set in the M5 Division on August the 14th at 8:30 a.m.
Su audiencia de instrucción formal de cargos está fijada en la división M5 el 14 de agosto a las 8:30 a.m.
Thank you, sir.
Gracias, señor.
My understanding is that is all the folks who require the assistance of the Spanish interpreter, but would you please make an announcement just to make sure?
Atención. Si alguien más necesitará asistencia o interpretación al español, levante su mano ahora.
All right, I see another person here. Can you please tell me your name, ma'am?
Señora, diga sus nombres completos, por favor.
Sandra Sandoval Rodríguez.
Sandra Sandoval Rodríguez.
All right. Ma'am, you're charged with driving without a valid driver's license.
Señora, se le acusa de conducir sin una licencia válida.
Would you like for me to appoint the Public Defender's Office to represent you, or are you going to hire your own attorney or represent yourself?
¿Desea usted que le asigne la oficina del defensor público para representarla o usted misma contratará un abogado privado o quiere representarse usted a sí misma?
Un defensor público.
A public defender.
I provisionally appoint the Public Defender's Office to represent you in this case.
Le nombro provisionalmente a la oficina del defensor público en este caso.
I have reviewed the citation and the arrest report. I do find probable cause for the charge.
Tras revisar el citatorio y el informe de arresto, determino que existe motivo fundado para el cargo.
In this case, I'm going to require pretrial release with bail as condition of pretrial release.
En este caso, exigiré libertad condicional con fianza como condición de la libertad condicional.
Your bail is set at $250.
Establezco su fianza en $250.
Once you are released, you must report immediately to Pretrial Release Services Office in person in Lake Alfred.
Una vez que la pongan en libertad, tendrá que reportarse inmediatamente, personalmente, a la oficina de servicios de libertad condicional ubicada en Lake Alfred.
At 200 Government Center Boulevard.
Ubicada en la 200 Government Center Boulevard.
Thereafter, you must report by phone every week, once a week on Thursdays.
Después tendrá que reportarse telefónicamente cada semana, una vez por semana, los jueves.
You may not drive without a valid driver's license.
Se le prohíbe conducir sin una licencia válida para conducir.
You have an arraignment hearing set in the M5 Division for August the 14th at 8:30 a.m.
Tiene una audiencia de instrucción formal de cargos fijada para la división M5 para el 14 de agosto, 8:30 a.m.
Thank you, ma'am.
Gracias, señora.
Is there anybody else who requires the assistance of the Spanish interpreter? I'm not seeing anybody. Thank you so much, and we appreciate your assistance.
You're welcome.
All right, are there any other private attorneys who are appearing by teams?
Good afternoon, Judge. Ricardo Alvarez on behalf of Luis Loredo, Loredo.
All right, hold on one second. Got it. All
The
right,
case number is 26 CF 6640, Judge.
thank you. All right, sir, you are charged with criminal mischief over $200 and under $1,000, aggravated assault with a deadly weapon, aggravated stalking, burglary of a conveyance with assault or battery while armed with a firearm. And it looks like these are all charges that the state directly filed an information on.
That is correct, Your Honor.
All right, what would you like to tell me?
Judge, I don't believe that there's a typo on this one when it says no bond. I believe the state is rising to request that he be held no bond. We will be filing a motion to set bond and schedule an Arthur hearing before Judge Carpenini on the burglary of a conveyance with a weapon.
Okay.
On the other charges, Judge, the court is more than welcome to set standard bond if you don't mind.
And yes, Your Honor, regarding the armed burglary charge, that is a first-degree life felony, so state is requesting the defendant be held no bond on that charge.
All right, in this case, I have reviewed the capias and the information on the complaint affidavit as to all of the charges with the exception of the burglary of a conveyance with assault or battery while armed with a firearm. I'm going to require pretrial release with bail as a condition of pretrial release. I'm going to require that GPS electronic monitoring is a condition of your pretrial release, and you may not be released until the GPS electronic monitor is affixed to your person. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone every day, 7 days a week. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives, and you're prohibited from having any contact with the victim or any witnesses in this case. You must stay at least 500 feet away from the victim and witnesses, their residences, vehicles, places of employment, and schools at all times. You may not contact the victims or witnesses directly or indirectly. You may not contact the victims or witnesses in any manner whatsoever. As to the criminal mischief charge, your bond is set at $1,000. As to the aggravated assault with a deadly weapon charge, your bond is set at $10,000. As to the aggravated stalking charge, your bond is set at $10,000. And right now, your bond status on the remaining charge of the burglary with an assault or battery while armed with a firearm, your bond status is no bond on that. I'm sorry, I couldn't hear you. All right,
My client is not speaking, it's somebody else.
Okay, somebody else is talking. Everybody needs to mute their microphones if this is not your case. All right, let me see when your hearing is. You're going to have a pretrial on, is that the right date? November 20?
That's just a status, I think, in not October or September, September.
All right. You said you have a status, so I'm seeing a status for October 2nd at F2 at 8:30 that the clerk's office filled in. Is that the correct date? And then a pretrial conference on November the 10th at 8:30 in F2. So I don't know if those are the correct dates, but that's what the clerk's office is telling me, okay?
Yes, Your Honor. Thank you.
Thank you very much. Y'all take care. Are there any other private attorneys on Teams?
Yes, Your Honor, Jennifer Hernandez on behalf of Amanda Plata.
All right, let me get there. All right, so Amanda Plata. Ma'am, you're charged with battery on a law enforcement officer, resisting an officer without violence, domestic violence battery, and resisting officer with violence. And your attorney is present virtually. I have, what would you like to tell me, Ms. Hernandez?
Yes, Your Honor, I believe the alleged victim on the battery DV is present, Mr. Martinez. He would like contact with Ms. Plata and would like for her to return home. So we would be asking for no hostile contact and allow them to still reside together. We would also be asking for a reasonable bond on all the counts.
All right, is there anything the state wants to tell me?
Not at this time, Your Honor.
One second, I'm just. So, is the victim present?
Yes, Your Honor.
Pull up the arrest report real quick. I don't, can the deputy help me locate, you're gonna need to put your camera on?
Yes, my camera is on.
Okay, hold on, let's see if the deputy can find where you are. Are you in a car? Are you in a car? The deputy's asking?
No, I got a red t-shirt.
Okay. Hold on, we're having difficulty locating you. So many people just have, only have like initials. All right, here we go. All right, sir, please raise your right hand. Do you swear or affirm the testimony you provide today will be the truth? I don't see your hand raised, your right hand raised. I don't see your right hand raised. That's, okay. It's your left hand, but. All right, do you swear or affirm the testimony you provide today will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Please state your full name.
Jeffrey Martinez.
Okay, I see that pretrial services reached out to you like they do in all of these cases, and that you didn't respond to them. Why was that?
Me?
Yes, sir. So pretrial services in all of these cases with victims, they call and ask a series of questions, asking a laundry list of questions to find out if there's been previous violence and a whole bunch of other things that are important for the court to know. And at least they didn't get a call back. They couldn't get a hold of you. Did you not get that call, or why didn't you respond to them?
Might be on work. I don't know anything about that. And I be answer all the calls. I don't know.
Okay, so the number that you have up on the screen is the number they have and the number that they tried to contact you at. But regardless, you're here now. So are you saying you want to have contact with the victim?
Yes, Your Honor.
Okay, and has there been any previous violence?
No.
Okay. Do you object to the defendant getting out of jail?
No, Your Honor.
Are you going to seek a restraining order?
Yes, Your Honor.
You said yes?
Yes, I want to remove the restriction order.
Are you, now my question is, are you going to seek a restraining order?
I wanted to remove.
Do you already have a restraining order against her?
The officer.
Just so you know, that's
The
not what
officer.
we're doing today.
Oh, okay.
Your Honor,
Never mind.
if I may, Your Honor, I think he is getting confused with the question. I think what he's trying to say is he wants to
Yeah.
remove the
Ma'am?
no contact.
Ma'am, I understand what he's saying, but he's going to ask my question, he's going to answer my questions, okay?
Understood.
All right, and then if you have any questions for him, you may certainly ask those, okay?
Yes, Your Honor.
All right. Do you fear further violence from the defendant?
No, Your Honor.
Okay, and I'm unclear, so are you telling me you didn't go down and petition for a restraining order, is that correct?
No, Your Honor.
Okay. Does the defendant possess a weapon?
No, Your Honor.
And do you and the defendant reside together?
Yes, Your Honor. We're married.
All right, and do you object to the defendant returning home?
No, Your Honor.
Does the defendant have another place to reside?
No, Your Honor.
Was the incident drug or alcohol related?
Alcohol related.
Is there anything else you want to tell me?
No, Your Honor.
All right. Does the defense have any questions?
No, Your Honor.
No.
One moment. Hang on, they're getting the paperwork for me. Of the arrest report. Thanks. Based upon the facts of this case, I am going to be requiring no contact at this time. All right. In this case, I'm going to require pretrial release with bail's condition of pretrial release. Your bail is set at $6,000 on the battery on a law enforcement officer charge, $1,000 on the resisting or obstructing an officer without violence charge, $5,000 on the domestic violence charge, and $6,000 on the resisting officer with violence charge. Once you are released, you must report immediately to Pretrial Release Services Office in person in Lake Alfred at 200 Government Center Boulevard. Thereafter, you must report by phone every week, 3 times a week on Mondays, Wednesdays, and Fridays. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives, and you're prohibited from having any contact with the victim in this case. You may not contact the victim directly or indirectly. You may not contact the victim in any manner whatsoever. You must stay at least 500 feet away from the victim's residence, vehicle, place of employment, and school at all times. I'm going to allow you a one-time return and one-time return only to the residence. However, it must be within 48 hours of your release from custody, and you must be accompanied by a law enforcement officer. The purpose for that one-time return is for you to quickly gather essential items, things such as clothing, medication, work tools, important paperwork, things of that nature. You have an arraignment hearing set in the A2 Division on September the 1st at 8:15 a.m. Thank you, everybody. Are there any other private counsel on Teams? All right, let's go to our in-person, and I believe that is Robert Brown. All right. All Good afternoon, Mr. Brown. You're here because the capias was issued for you in Polk County case number 2026 CF 3126. It was an order regarding pretrial release. The judge issued an order after they received an affidavit of violation of pretrial release. And so the judge who was assigned to that case issued a no bond capias. Would you like for me to appoint the public defender's office to represent you, or are you going to hire your own attorney or represent yourself?
I was in jail.
You're just PD.
All right.
I was in jail.
So I'm here to do the things that we talked about. The judge issued it, and if you have any defenses, you're going to have to present those defenses to the judge who's got the case. So the clerk is telling me while you're talking that the public defender's office has already been appointed to represent you, and they will continue to represent you. Right now, you do have that no bond capias, so that's the situation. And you will go for a hearing in the F1 division on...
He's going to pretrial after he's done here.
Okay, I was going to say that's today's date.
Yes.
And then we're past 1 o'clock. All right, so you're going to leave this courtroom and you go right down to the F1 division to have a hearing on this matter, okay?
Yes, but they know I was in jail, right?
I'm not here for any of that.
I got it.
Thank you, sir.
Yes, ma'am, thank you.
Thank you.
All right.
All right, so let's...
Oh, I apologize. I walked off on you.
No, we were done.
Okay.
All right, thank you. Take care.
Yes, ma'am.
All right, so now we're going to go to South County Jail. The first case we have is Eduardo Alicia Gonzalez. And after that is going to be Emmanuel Fernandez. All right, Mr. Alicia Gonzalez, you're here because you have a capias from Polk County case number 2026 CT 5085 for failure to appear at arraignment. Does he have counsel appointed? Would you like for me to appoint the public defender's office to represent you, or are you going to hire your own attorney or represent yourself?
Public defender, please.
All right, I provisionally appoint the public defender to represent you in this case. I have reviewed the capias. I do find probable cause. Your bonds is set at $500 per the capias, and you'll have a hearing, an arraignment hearing in the M5 division on August the 14th at 8:30 a.m. Thank you, sir.
Thank you.
Going on to Emmanuel Israel Fernandez. Sir, you're charged with 2 counts of battery on a law enforcement officer, resisting or obstructing an officer without violence, and resisting or obstructing an officer with violence. Would you like for me to appoint the public defender's office to represent you?
No, ma'am. No, Your Honor, I will hire my own lawyer.
All right, the clerk will note down that you're going to hire your own attorney. In this case, I have reviewed the arrest report, and I do find probable cause for all the charges. I'm going to require a pretrial release with bail as a condition of pretrial release. Your bail is set at $1,000 on the resisting or obstructing an officer without violence charge and $5,000 on each of the other accounts. Once you are released, you must report immediately to Pretrial Release Services office in person in Lake Alfred at 200 Government Center Boulevard. Thereafter, you must report by phone every week, three times a week on Mondays, Wednesdays, and Fridays. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. And you're prohibited from having any intentional contact with the law enforcement officers. You must stay, you may not contact them directly or indirectly. You may not contact them in any manner whatsoever. You must stay at least 500 feet away from the law enforcement officer victims, their residences, their vehicles, and their schools. Thank you, sir. You're going to have an arraignment hearing in the A2 division on September the 1st at 8:15 a.m.
Thank you, Your Honor.
Thank you. All right, moving on to Azo Jackson. Mr. Jackson, you're charged with resisting an officer without violence, use or possession of drug paraphernalia, possession of MDMA, ecstasy, burglary with assault or battery, and domestic violence battery with a prior conviction. Would you like for me to appoint the public defender's office to represent you, or are you going to hire your own attorney or represent yourself?
Yes, ma'am. I'd like to, for you to hire me a lawyer.
You want the public defender's office, is that what you're saying?
Yes, ma'am.
Okay, I provisionally appoint the Public Defender's Office to represent you, and I see the Assistant State Attorney is at the lectern.
Yes, Your Honor. Regarding the burglary with an assault or battery charge, as it is a first-degree felony punishable by life, state is requesting the defendant be held no bond on that count.
All right. Sir, as to all of the charges, with the exception of the burglary with assault or battery, I'm going to require pretrial release with bail's condition of pretrial release. Your bail is set at $1,000 on the resisting officer without violence charge, $1,000 on the drug paraphernalia charge, $5,000 on the MDMA ecstasy charge, and your bond is set at $6,000 on the burglary with the prior conviction charge. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone every week, 3 times a week on Mondays, Wednesdays, and Fridays. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives, and you're prohibited from having any contact with the victim in this case. You may not contact the victim directly or indirectly. You may not contact the victim in any manner whatsoever. You must stay at least 500 feet away from the victim's residence, vehicle, place of employment, and school at all times. You also must submit to random urinalysis that you're required to pay for. I'm going to allow you a one-time return to the residence and one time only. However, that must occur within 48 hours of your release from custody, and you must be accompanied by a law enforcement officer. And as to the remaining charge, the burglary with assault and battery, right now your bond status is no bond on that charge. But you have an arraignment hearing set for September the 1st at 8:15 a.m. in the A2 division. Thank you, Mr. Jackson.
Ma'am, you said I have, if I do bond out, let's say I do bond out or get a bond on the other case, you saying that I can't go back to the residence? That's my residence.
I told you you can do the one-time return, and I told you under what conditions. Thank you, sir. Please step to your left. Next
You
case
said a
is
one-time
Calvin
condition
Lopez.
to
Yes,
my
sir.
own-
Please step to your left. You're
Done.
done. Calvin Lopez. All right, Mr. Lopez, you're charged with trafficking in fentanyl, 14 grams, but less than 28 grams. Would you, as well as possession or use of drug paraphernalia. Would you like for me to appoint the public defender to represent you?
Yes, ma'am.
I provisionally appoint the public defender to represent you in this case. I have reviewed the arrest report. I do find probable cause for the charges. And I see the Assistant State Attorney is at the lectern. What would you like to tell me?
May I approach, Your Honor?
You may.
Your Honor, this is a motion for pretrial detention as it relates to the trafficking charge. Should Your Honor find this motion to be legally and facially sufficient, the state would request a pretrial detention hearing to be set next Monday, August 3rd at 1 p.m. on the A2 docket.
All right, the state has presented me a motion for pretrial detention on the trafficking charge, asking that I hold you no bond on that charge. I'm going to review their motion to see if it is legally sufficient. I have reviewed the state's motion for pretrial detention, and I do find that it is legally sufficient. As to the charge of use or possession of drug paraphernalia, I'm going to require pretrial release with bail's condition of pretrial release. Your bail is set at $2,000. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report 2 times a week on Tuesdays and Thursdays, and you must submit to random urinalysis that you're required to pay for. As to the trafficking charge, your bond status at this time is no bond. However, you will have a hearing in the A2 division on August the 3rd at 1 o'clock p.m., and you have an arraignment September the 1st in the A2 division at 8:15. Thank you, sir, and good luck. All right, that one. Let's go on to Jalen Nance. All right, Mr. Nance, you're charged with use or possession of drug paraphernalia, possession of cocaine, possession of alprazolam, Xanax, possession of fentanyl, possession of harmful new legend drug without a prescription. And then at least my docket says that you have a fugitive from justice charge out of Georgia, but I don't have any paperwork on that specific charge, so I don't know if anybody else does. Okay, it's been added since I looked in the court file earlier, so let me take a look at that one real quick. All right, it looks like that fugitive from justice charge comes out of Spalding County Sheriff's Office for battery family violence, and right now they have your bond status set at no bond. Would you like for me to appoint the Public Defender's Office to represent you on these matters, or would you like to hire your own attorney or represent yourself?
Wait, can you repeat that again and where? And where at?
Spalding County, Georgia.
And
Would you like
said that.
Would you like for me to appoint the Public Defender's Office to represent you, or are you going to hire your own attorney or represent
Yeah,
yourself?
can you appoint me to present?
The Public Defender?
Yeah.
I provisionally appoint the Public Defender to represent you. I have reviewed the arrest reports. I do find probable cause for all of the charges. Right now, Spalding County, Georgia has your bond status set at no bond on the fugitive from justice charge out of there. As to the Polk County charges, I'm going to require pretrial release with bail as a condition of pretrial release. Your bail is set at $1,000 on the drug paraphernalia charge, $250 on the possession of harmful new legend drug without prescription, and $5,000 on each of the remaining counts. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone every week, 2 times a week on Tuesdays and Thursdays.
Can I ask you? I didn't mean to cut you off.
Sir, stop interrupting and let me finish. Then I will see if you have questions. You must submit to random urinalysis that you're required to pay for. You have an arraignment hearing on September the 1st at 8:15 a.m. and you have a hearing regarding the Georgia case in the F7 division on August 4th at 8:29 a.m. Yes, sir.
Okay, so would I be able to bond out of here or no because of Georgia?
You can bond out on the Polk County charges. Right now, you cannot bond out on the Georgia charge.
So the Georgia is coming to get me?
You can talk to your attorney about that I appointed. Thank you, sir. Please step to your left. Moving on to Gerardo Puente. Sir, you're charged with robbery with firearm, tampering with a witness in a first-degree felony, and kidnapping, committing, or facilitating a commission of a felony. Would you like for me to appoint the public defender to represent you, or are you going to hire your own attorney to represent
Public defender, Ms. Gary.
I provisionally appoint the Public Defender's Office to represent you in this case. I have reviewed the arrest warrant and the complaint affidavit. I do find probable cause for all the charges. I see the Assistant State Attorney is at the lectern. What would you like to tell me?
Yes, Your Honor. Regarding the robbery charges, that is a first-degree felony punishable by life, and the kidnapping charge is a first-degree life felony. State is requesting the defendant be held no bond on those 2 counts.
All right. The state is asking that I hold you no bond on the 2 counts that they stated. As to the remaining first-degree felony, tampering with a witness charge, as to that charge only, I'm going to require pretrial release with electronic monitoring, with electronic GPS monitoring as a condition of pretrial release, along with bail. Your bail is set at $20,000 on that charge. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. You may not be released until the GPS electronic monitor is affixed to your person. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives, and you are, can you pull up the warrant real quick? Hang on 1 second. And the judge who issued the warrant, additionally, in addition to you not being able to use, possess, or carry any firearms, guns, weapon, ammunition, or knives, you are prohibited from having any contact with the victim in this case. You may not contact the victim directly or indirectly. You may not contact the victim in any manner whatsoever. You have to stay at least 500 feet away from the victim's residence, vehicle, place of employment, and school at all times. You have a arraignment hearing in the A2 division on September 1st at 8:15 a.m. And as to the remaining 2 charges of robbery with a firearm and the kidnapping charge, your bond status is no bond at this time. Thank you, sir. Moving on to Elijah Juan Roby.
Yes, you went back to us. I have a
Carlos, he went back because he was combative inside the court.
All right, well, let's bring him back tomorrow and see if he's having a better day, please. Okay, that brings us, and same thing with Eduardo Santos, correct?
Say it again, Judge?
And that it's the same situation with Eduardo Santos, right?
Yes.
All right, let's see if they're having a better day tomorrow and we'll bring them back tomorrow. All right, the next case is Cornell Savage Jr. All right, sir, you are charged with petty theft with 2 previous convictions. Use of a credit card to obtain goods one time less than $100, and theft, taking, retaining credit card of another. Additionally, Health Services says that Mr. Savage is on felony probation in case number 2025 CF 5580. I would note that my paperwork has, can you pull up the warrant, please? The arrest warrant I see, it's not listed on my docket, but I see a 5th charge of fraudulent use of an ID without consent of a victim who is 60 years of age or older. So it appears that there is a 5th charge. Has that 5th charge been addressed in any fashion, or is it just accidentally left off the docket? Because it's on the arrest warrant. So it's kind of looking at what I'm seeing, the clerk, the paperwork they're flashing up there, it kind of looks like maybe he wasn't booked in on that 5th charge.
I don't think he was booked on that 5th charge, Judge.
All right, so, sir, we're going to, as to the 5th charge, we're going to end up having to bring you back tomorrow, unfortunately. I'm sorry that that happened, but we need to get all the charges addressed for. But I am going to go ahead and address the remaining charges. Would you like for me to appoint the Public Defender's Office to represent you?
Yes.
I provisionally appoint the Public Defender's Office to represent you in this case. I have reviewed the arrest warrant and the complaint affidavit. I do find probable cause for all of the charges. As to, I'm going to require pretrial release with bail as condition of pretrial release. Your bail is set at $5,000 on the petty theft with 2 prior conviction charges, $1,000. Pull up the warrant real quick. I just want to make sure that it's not a typo. They're just getting the paperwork for me. Your bail is set at $1,000 on the use of a credit card to obtain goods one time less than $100, $1,000 on the unlawful possession of personal ID of 4 or less, and $1,000 on the theft, taking, retaining credit card of another per the warrant. Again, you'll be brought back on that 5th charge tomorrow. Once you are released, you must report immediately to Pretrial Release Services Office in person in Lake Alfred at 200 Government Center Boulevard. Thereafter, you must report by phone every week, 3 times a week on Mondays, Wednesdays, and Fridays. The warrant requires that you have a curfew imposed, so you have it imposed as a curfew of 10 p.m. until 6 a.m., 7 days a week. Additionally, you may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You'll be brought back tomorrow on that 5th charge. And you, can you go back to the, that's okay, to the date. You have an arraignment hearing set in the A2 Division on August the 18th at 8:15 a.m. We'll see you tomorrow, Mr. Savage. All right, that brings, yes, ma'am.
Did you do the instanter?
I didn't hear anybody say anything after I mentioned it, so. Is he there or not? All right, we'll just address it tomorrow.
Strong.
Let's go to Casvin Stroman. Mr. Stroman, you're charged with violation of probation out of Gadsden County. And so since it's the Gadsden County case, it cannot appoint a Polk public defender to represent you. Are you going to hire your own attorney or represent yourself?
Neither. I don't know. I mean, you said it had 7 days to come get me. They ain't come get me.
Is this a bring back?
Yeah. Yes, ma'am.
Hold on, let me ask the courtroom personnel. Okay, sorry, nobody mentioned that to me and you weren't on my list. All right, so do we have any information about Gadsden County being contacted? Does anybody have any information from the state or pretrial or the clerks or the defense?
State has nothing, Your Honor.
All right, well, this is a violation of probation. So I am going to give them until next Wednesday to come and get you. So what's Wednesday's date?
They just had to last week Thursday to come get me.
The 5th, Judge.
All right, if you're still in our custody on August 5th, then you'll be brought back. Thank you, sir. Moving on, is there one other person at South County, or are they all finished? All right,
They all
finished. Thank you. All right, let's go on to the females at Central, and the first one is Lara Alexandra. All right, ma'am, you are charged with 7 counts of violation of probation from Polk County case number 2024 CF 010968. Would you like for me to appoint the public defender's office to represent you, or you can hire your own attorney or represent yourself?
My own attorney.
Okay, the clerk will note down that you're going to hire your own attorney. All right, I have reviewed the violation of probation corrected warrant and the corrected affidavit of violation of probation. I do find probable cause for all of the charges. Because they're VOPs, your bond status is no bond, but you'll have a VOP arraignment hearing in the F7 division on August the 25th at 8:30 a.m. Thank you, ma'am. The next case is Lorenzo Alessandra. All right, so ma'am, you're charged with violation of probation, but I will say from the paperwork I was given, so again, I'm going to be asking everybody in the courtroom, I can't tell which county it's from. I did go back and look at some paperwork, and I knew she had a violation of probation from Hillsborough County. But do the parties, does anybody know which county this is from?
It says Hillsborough.
Okay, I didn't have that on mine, so I'm glad y'all know it. All right, so since this is a Hillsborough violation of probation case, ma'am, I cannot appoint a public defender to represent you. But when you get to Hillsborough County, you can certainly ask the judge to appoint the public defender there if you qualify, okay? All right, I have reviewed the arrest report. I do find probable cause. Your bond status, because it's a VOP, is no bond. If Hillsborough County hasn't picked you up by August the 6th, you will be brought back here to first appearance. Thank you, ma'am.
Thank you.
Hannah Bradley. Ms. Bradley, you're charged with use or possession of drug paraphernalia and possession of methamphetamine. Would you like for me to appoint the public defender's office to represent you, or are you going to hire your own attorney to represent yourself?
Public defender.
I provisionally appoint the public defender to represent you. I have reviewed the arrest report. I do find probable cause for the charges. In this case, I'm going to require pretrial release with bail's condition of pretrial release. Your bail is set at $5,000 on the methamphetamine charge and $1,000 on the paraphernalia charge. Once you are released, you must report immediately to Pretrial Release Services Office in person in Lake Alfred at 200 Government Center Boulevard. Thereafter, you must report by phone every week, twice a week on Tuesdays and Thursdays. You must submit to random urinalysis that you're required to pay for. And you have an arraignment hearing set in the A2 division on September the 1st at 8:15 a.m. Thank you, ma'am. Next case is Nicola Brown. Ms. Brown, you're charged with aggravated assault with a deadly weapon. Would you like for me to appoint the public defender's office to represent you, or are you going to hire your own attorney or represent yourself?
Public defender.
I provisionally appoint the public defender's office to represent you. I have reviewed the arrest report. I do find probable cause for the charge. I'm going to require pretrial release with bail's condition of pretrial release. Your bail is set at $7,500.
What? I'm getting out tonight.
Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone every week, 3 times a week, on Mondays, Wednesdays, and Fridays. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives, and you're prohibited from having any contact with the victims and the witnesses in this case. You may not contact the victims or witnesses in any manner whatsoever. You may not contact them directly or indirectly. You must stay at least 500 feet away from the victims and the witnesses, their residences, their vehicles, places of employment, and schools at all times. You have an arraignment hearing set in the A2 Division on September the 1st at 8:15 a.m. Thank you, ma'am. Jessica Brunson. Ms. Brunson, you're charged with misdemeanor possession of cannabis and possession or use of drug paraphernalia. Would you like for me to appoint the Public Defender's Office to represent you?
Yes, please.
I provisionally appoint the Public Defender's Office to represent you. And Ms. Brunson, you live in Virginia, is that correct?
Yes, ma'am.
All right, I'm going to be asking the state and the defense about that in just a moment, because we have a standard condition that does not allow folks to leave the state of Florida. But this is obviously a different situation because you reside outside the state of Florida. So when we get there, I'm going to be asking them about that, okay?
Yes,
In
ma'am.
this case, we're going to require a pretrial release with bail as condition of pretrial release. Your bail is set at $2,000 on each count. Once you are released, you must report immediately to Pretrial Release Services Office in person in Lake Alfred at 200 Government Center Boulevard. Thereafter, you must report by phone every week, 2 times a week on Tuesdays and Thursdays. You must submit to random urinalysis that you're required to pay for. All right, we're to the point where I'm going to ask the state and the defense about the standard condition about not leaving the state of Florida with her living in Virginia. What says the defense?
Judge, I'd request the court waive that condition. These are misdemeanor offenses.
All right.
Say there's no objection, Your Honor.
All right, and that's certainly reasonable. That sounds reasonable to me as well. All right, ma'am, since you do reside in Virginia, I am going to allow you to leave the state of Florida to return to your residence in Virginia. But you must be back for all of your court hearings, or else you will have a capias issued for your arrest, okay?
Yes, ma'am.
You have an arraignment hearing set in the M5 Division on August the 14th at 8:30 a.m. Thank you, ma'am.
Thank you.
Next case, let's see, that one is Royette Davis. Ma'am, you're charged with career offender failing to register and provide information. Would you like for me to appoint the public defender to represent you?
Yes, ma'am.
I provisionally appoint the Public Defender's Office to represent you in this case. I have reviewed the arrest report. I do find probable cause for the charge. In this case, I'm going to require a pretrial release with GPS electronic monitoring and bail as condition of pretrial release. You may not be released until the electronic monitor is affixed to your person. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone 7 days a week, every day of every week. I'm also imposing a curfew from 6 p.m. until 6 a.m. and your bail is set at $10,000. You have a arraignment hearing set in the A2 Division for September 1st at 8:15 a.m. Thank you, Ms. Davis.
Thank you.
Patricia Dexter. Ms. Dexter, you're charged with trespass, failure to leave property on order of owner. Would you like for me to appoint the public defender to represent you?
Yes, ma'am.
I provisionally appoint the public defender to represent you in this case. I have reviewed the arrest report. I do find probable cause for the charge. In this case, I'm going to require a straight bond in the amount of $1,000. But the condition of the bond is that you stay at least 500 feet away from the event location from this case.
Yes,
You have an arraignment hearing in the M5 Division on August the 14th at 8:30 a.m. Thank you, ma'am, and good luck to you. Moving on to Melissa Gibson. All right, Ms. Gibson, you are charged with cannabis possession not more than 20 grams, possession or use of drug paraphernalia, tampering with physical evidence, and trafficking in amphetamine, methamphetamine, 14 grams or more. Would you like for me to appoint the Public Defender's Office to represent you?
Yes, ma'am.
provisionally appoint the Public Defender's Office to represent you in this case. I have reviewed the arrest report. I do find probable cause for all of the charges. I see the Assistant State Attorney is at the lectern.
Madam Pro Tem.
You may.
Your Honor, this is a motion for pretrial detention as it relates to the trafficking charge. Should Your Honor find this motion to be legally and facially sufficient, the state would request a pretrial detention hearing to be set next Monday, August 3rd at 1 p.m. on the A2 docket.
All right, Ms. Gibson, as to the trafficking charge, the state has filed a motion for pretrial detention, and they're asking that I hold you no bond on that case. I'm going to take a moment and review their motion for legal sufficiency. All right, I have reviewed the state's motion for pretrial detention, and I do find it to be legally sufficient. As to all of the other charges, with the exception of the trafficking charge, I'm going to require pretrial release with GPS electronic monitoring and bail as condition of pretrial release. You may not be released until the GPS electronic monitor is affixed to your person. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone every day, 7 days a week. You must submit to random urinalysis that you're required to pay for, and I'm imposing a curfew from 6 p.m. until 6 a.m. Your bond on the misdemeanor cannabis is set at $1,000. Your bond is set at $1,000 on the paraphernalia charge. Your bond on the tampering with physical evidence charge is set at $6,000. You have an arraignment hearing in the A2 division on September the 1st at 8:15 a.m. and your bond status on the trafficking charge at this time is no bond, but you will have a hearing on that matter on August the 3rd at 1 o'clock p.m. in the A2 division. Thank you, ma'am.
Thank you.
I curfew, GPS, and the random urinalysis. Yes, sir. All right, so that brings us to Alexis Johnson. All right, ma'am, you are charged with criminal use of a personal ID of a person 60 years of age or older, misdemeanor possession of cannabis, use or possession of drug paraphernalia, fraudulent use of a credit card more than 2 times, scheme to defraud, and grand theft $750 to $5,000. Would you like for me to appoint the Public Defender's Office to represent you?
Yes, ma'am.
I provisionally appoint the Public Defender's Office to represent you in this case. I have reviewed the arrest warrant and the complaint affidavit. I do find probable cause for all the charges. I'm going to require a pretrial release with bail as condition of pretrial release. Your bail is set at $10,000 on the criminal use of personal ID of a person 60 years of age or older, $1,000 on the misdemeanor possession charge, $1,000 on the paraphernalia charge, $5,000 on the fraudulent use of credit card more than 2 times charge, $5,000 on the scheme to defraud, and $5,000 on the grand theft charge. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone every week, 3 times a week on Mondays, Wednesdays, and Fridays. You are prohibited from having any contact with victims in this case. You may not contact the victims directly or indirectly. You may not contact the victims in any manner whatsoever. You must stay at least 500 feet away from the victims, their residences, vehicles, places of employment, and school at all times. You also must submit to random urinalysis that you're required to pay for. In this case, you're going to have an arraignment hearing set. It's already been set for August the 18th at 8:15 a.m. in the A2 division. What's the...
There's 2, plus it's a felony and a misdemeanor.
Okay, and then in the misdemeanor case, you have an arraignment hearing set for August the 14th at 8:30 a.m. in the M5 division, and they'll give you paperwork that has all that on that. Okay, all that on there. Okay.
Yes, ma'am.
Thank you. Take care.
Thank you.
Moving on to Liliana Montanez. Ma'am, you're charged with domestic violence, aggravated assault with a deadly weapon, and domestic violence battery. Would you like for me to appoint the Public Defender's Office to represent you?
Yes, Your Honor.
I provisionally appoint the Public Defender's Office to represent you. I have reviewed the arrest report. I do find probable cause for the charges. In this case, I'm going to require a pretrial release with bail as condition of pretrial release. Your bail is set at $6,000 on the aggravated assault charge and $5,000 on the domestic violence battery charge. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone every week, 3 times a week on Mondays, Wednesdays, and Fridays. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives, and you're prohibited from having any contact with the victim in this case. You may not contact the victim directly or indirectly. You may not contact the victim in any manner whatsoever. You must stay at least 500 feet away from the victim's residence, vehicle, place of employment, and school at all times. I'm going to allow you a one-time return to the residence and one time only. However, that must occur within 48 hours of your release from custody, and you must be accompanied by a law enforcement officer. The purpose for that one-time return is for you to quickly gather essential items, things such as clothing, medication, work tools, important paperwork, things of that nature. You have an arraignment hearing set September the 1st at 8:15 a.m. in the A2 division. Thank you, ma'am. All right, that brings us to Driana Thomas. Ms. Thomas, you are charged with criminal conspiracy to violate, it says, the Racket Act, defraud to obtain property with a value of $50,000 or more, and 2 counts of dealing in stolen property. Would you like for me to appoint the Public Defender's Office to represent you?
Yes, ma'am.
I provisionally appoint the Public Defender's Office to represent you in this case. I have reviewed the arrest warrant and the complaint affidavit. I do find probable cause for all of the charges. Is there anything the state or the defense wants to tell me?
Good afternoon, Judge. This is Stephanie Pizarro with the Office of Statewide Prosecution. I'm present remotely.
All right, let's see if we can get your, we're going to jostle around some of these icons and see if I can get you up here on camera.
Thank you, Judge.
There we go. All right, what would you like to tell me?
Judge, the defendant is one of 6 who have been charged in this matter. 2 have already come before first appearance, and the state is similarly, as we've done with the other 2 defendants, asking for a heightened bond in Ms. Thomas's case based on the volume and in the amount of thefts and frauds that were committed across the state of Florida, all of which were committed by Ms. Thomas in between 2 different prison terms. She has 14 prior felonies, all of which are theft related, and she also has 4 prior failure to appears and 3 prior violations of probation. And so the court, the state is requesting a GPS monitor and is also requesting $100,000 in bond on the conspiracy to commit RICO and organized scheme, and $15,000 on the 2 dealing in stolen properties, along with the ordinary conditions of no contact with co-defendants and no contact with the business victims in this case.
All right, and hold on one second. And what about the remaining charge of defraud to obtain property of value of $50,000 or more?
Judge, I apologize. I set that as organized scheme to defraud, but I'm asking for $100,000 on the conspiracy to commit RICO and on the organized scheme to defraud. I just forget the wording as the court just said it.
Yes, ma'am.
Okay. Mr. Pinkett?
As Judge, the state's not offering any evidentiary basis for this. If they'd like to have an evidentiary hearing to demonstrate it, that'd be something else. In the meantime, I'd ask the court to impose standard bonds. Obviously, I have no objection to electronic monitoring, no contact with co-defendants.
All right. In this case, I am going to require pretrial release with GPS electronic monitoring and bail as condition of pretrial release. Ma'am, you may not be released until the GPS electronic monitor is affixed to your person. Once you are released, you must report immediately to Pretrial Release Services Office in person in Lake Alfred at 200 Government Center Boulevard. Thereafter, you must report by phone every day, 7 days a week. I am also going to require house arrest. However, you may attend your own court hearings, you may attend your own attorney appointments, and you may attend your own medical appointments. You are prohibited from having any contact with victims in this case. You may not contact the victims directly or indirectly. You may not contact the victims or their employees in any manner whatsoever. You must stay at least 500 feet away from the victims, their places of business, and you must stay at least 500 feet away from all of their employees. Additionally, you're prohibited from having any contact with the co-defendants in this case. I am going to require a bond on the conspiracy charge in the amount of $50,000. The defraud to obtain property value of over $50,000, I am going to require bond in the amount of $50,000. The two dealing in stolen property charges, your bond is set at $10,000 on those. You have an arraignment hearing set August the 18th at 8:15 a.m. in the A2 division. Thank you very much, everybody.
Thank you.
All right. I believe that's all the females at South County, at Central, so let's go to the males at Central. The first case is Michael Archer. All right, Mr. Archer, you are charged with possession of a concealed weapon by a convicted felon and DUI third violation within 10 years. Would you like for me to appoint the public defender's office to represent you?
The 3 DUI in 10 years is false.
All right, well, at least when I looked at your record, I saw DUIs, I saw two previous ones, one from 2024, one from 2022.
The 2022 is was the original one. I copped out to it in 2024. That's why it's messed up.
All right, great. So at least that's the information I have right now. Would you like for me to?
County could tell you everything. Yes, ma'am.
Right, sir, but my question to you, this isn't the trial. You heard what we're here to do.
Yes,
my
ma'am.
question to you is, would you like for me to appoint the public defender's office to represent
Yes, ma'am.
you? All right,
Yes,
I
ma'am.
provisionally appoint the public defender to represent you in this case. I have reviewed the citations and the arrest report. I do find probable cause for the charges. In this case, I'm going to require pretrial release with bail as a condition of pretrial release. Your bail is set at $10,000 on the DUI charge and the $15,000 on the remaining charge. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone every week, 3 times a week on Mondays, Wednesdays, and Fridays. You may not use, possess, or consume any alcohol or enter any bars or lounges. And you must submit to both random breath tests and random urinalysis. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives, and I'm imposing a curfew from 6 p.m. until 6 a.m. You have an arraignment hearing set in the A2 division on September the 1st at 8:15 a.m. Thank you, Mr. Archer. Charles Birdsong. Mr. Birdsong, and you're here because you're here because you have orders revoking your pretrial release because an affidavit of violation of pretrial release was submitted. I have reviewed those orders as well as the capias in this case, and it's regarding 3 Polk County cases, 2026 MM 4136, 2026 CT 3775, and 2026 CT 3774. Would you like for me to appoint the Public Defender's Office to represent you in these cases? Or are you going to hire your own attorney or represent yourself?
Judge, he has a PDF.
I already have a public defender in those cases, ma'am.
Thank you, sir. And that's, the clerk just said the same thing. So they will continue to represent you. All right, I have reviewed the documents that I already outlined. I do find probable cause for all of the charges. The judge who issued the capias set your bond status at no bond, but we are going to have a 5-day hearing. So your 5-day hearing will occur in the M5 division on August the 3rd at 8:30 a.m. And you have a mandatory docketing hearing set in that same division on August the 26th at 8:30 a.m. Thank you, Mr. Birdsong. Next case is Ian Braxton. And I think I saw Mr. Braxton earlier this week. And for
Yes,
those
ma'am.
of you who weren't here, there were two, I brought up at that time, there were two affidavits with two different alleged domestic violence events. However, he had not been booked in on one, and he was supposed to be brought back yesterday. So I'm not sure what happened in between, but it looks like we are here on that second charge that we previously discussed at our other first appearance hearing. And I believe at that time I appointed the public defender's office. Is that correct?
Yes, ma'am.
Previous case. So would you like for me to also appoint the public defender's office to represent you on the second case?
Please.
I provisionally appoint the public defender's office to represent you in this case. I do find, after reviewing the arrest report, I do find probable cause for the charge. In this case, I'm going to require pretrial release with bail as condition of pretrial release. Your bail is set at $5,000. Once you are released, you must report immediately to pretrial release services office in person in Lake Alfred at 200 Government Center Boulevard. Thereafter, you must report by phone every week, 3 times a week on Mondays, Wednesdays, and Fridays. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives, and you're prohibited from having any contact with the victim in this case. I know when we had our other hearing earlier this week, based upon what was put in the court file, I told you at that time, and I'm going to remind you, you cannot contact the victim directly or indirectly, and that means you can't contact the victim in any manner whatsoever. And you certainly can't have your mom or anybody else contact the victim and try to talk to the victim about saying certain things, okay?
Yes, ma'am.
All right,
I do also have a question.
hold on a second. We'll get there. You may not contact the victim directly or indirectly. You cannot contact the victim in any manner whatsoever. You have to stay at least 500 feet away from the victim's residence, vehicle, place of employment, and school at all times. I allowed you in the other case, and I'm going to allow you in this case, a one-time return to the residence and one time only. However, that must occur within 48 hours of your release from custody, and you must be accompanied by a law enforcement officer. And you have an arraignment hearing in the M5 division on August the 14th at 8:30 a.m. Yes, sir.
So for my last case, I was allowed to go to Bartow instead of Lake Alfred. Could I do the same with this one as well?
Yes, sir, you can. So once you are released, you must report immediately to pretrial release services office in Bartow at 1745 South Highway 17. Thank you for that reminder. I appreciate it.
Thank you, Your Honor.
Thank you. Take care, sir.
You as well.
Casey Breaker.
Your Honor, he was transferred to South County.
He was transferred to South County?
Yes, ma'am.
All right, so I guess we'll bring him back tomorrow. Is that what I'm hearing?
Yes, ma'am.
All right, we'll bring him back tomorrow. And then I'm going to be asking for anyone who's, if y'all are going to be here tomorrow, we're trying to figure out where he's on probation out of. It says interstate, so that'll be an interesting discussion for tomorrow. All right, next case is Damian Bino. All right, so you're here because you have a warrant out of Orange County for grand theft. It says 3rd degree. And I cannot appoint a Polk public defender to represent you since it's Orange County. But once you get to Orange County, you can certainly ask the judge there to consider appointing the public defender if you qualify, okay?
All right.
I have reviewed the arrest report and the warrant confirmation teletype. I do find probable cause for the charge. Orange County has set your bond status at $2,500, and they have required the following conditions of bond: no return to the scene of the offense, and no contact with the witnesses or the victims. If you are still in our custody on August 6th, we'll bring you back to first appearance here, okay?
Yes, ma'am.
Thank you, sir. Junel Caballero. Sir, you're here because You have 3 counts of violation of probation from Polk County case number 2025 CF 4299. Would you like for me to appoint the public defender's office to represent you, or are you going to hire your own attorney or represent yourself?
Public defender.
I provisionally appoint the public defender's office to represent you. I have reviewed the BOP arrest warrant and the affidavit of violation of probation. I do find probable cause for the charges. Because they're VOPs, right now your bond status is set at no bond. But you do have a VOP arraignment hearing in the F7 division on August 25th at 8:30 a.m. Thank you, sir.
The 25th?
August the 25th, yes, sir. Rodney Coleman. Mr. Coleman, you're charged with use or display or carrying a concealed firearm during a felony offense, use or possession of drug paraphernalia, cannabis possession over 20 grams, DUI, and refusal to submit to a DUI test. Would you like for me to appoint the public defender's office to represent you, or are you going to hire your own attorney or represent yourself?
Yes, you can appoint one.
I provisionally appoint the public defender's office to represent you. I have reviewed the citations and the arrest reports. I do find probable cause for all of the charges. In this case, I'm going to require pretrial release with bail as a condition of pretrial release. Your bail is set at $10,000 on the F2 use or display or carrying a concealed firearm during a felony offense, $1,000 on the drug paraphernalia charge, $5,000 on the felony cannabis charge, $2,000 on the DUI charge, and $250 on the remaining charge. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone every week, 3 times a week on Mondays, Wednesdays, and Fridays. You must submit to random breath tests and random urinalysis that you're required to pay for. You may not use, possess, or consume any alcohol or enter any bars or lounges. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives, and I am imposing a curfew from 6 p.m. until 6 a.m. You have 7 days a week. You have an arraignment hearing scheduled in the A2 division on September the 1st at 8:15 a.m. Thank you, Mr. Coleman. All right, the next case is Tyler Douglas.
Yes,
Mr.
ma'am.
Douglas, you're charged with driving while license permanently revoked or canceled, and 3 counts of violation of probation from Polk County case number 2021 CF 5992. Would you like for me to appoint the public defender's office to represent you in these matters?
Yes, ma'am. May I ask you a question, or I have to do that after this, after everything?
All right. Yes, sir. What's your question?
When you say permanently, does that mean that it's forever? Like, I can't get a license? I never can get a license?
Well, I can't go into giving you legal advice, so that's not a question I can answer. But since you did ask me to appoint the public defender's office, I am going to provisionally appoint them to represent you in this case. And that's certainly something you can talk to them about when you see them.
Yes, ma'am.
I have reviewed the citation and the arrest reports. I do find probable cause for all of the charges. On the violation of probation charges, because they're VOPs, your bond status is no bond. And on the other charge, on the felony driving while license suspended charge, your bond status is set in the amount of $7,000. Once you're released, you must report immediately to Pretrial Release Services Office in person. Hang on one second, they're going to get a location for me. In Bartow at 1745 South Highway 17. Thereafter, you must report by phone every week on Tuesdays and Thursdays. You may not drive without a valid driver's license. You have an arraignment hearing on September the 1st at 8:15 a.m. in the A2 division. Is that the only one? Okay, thank you, sir.
Yes, ma'am.
Next case is Henry Dowling.
No, Dowling. Dowling, that's our name.
He has a private attorney?
Yes.
Mr. Dowling, who's your attorney?
I can't remember her name 100%, Your Honor. I have a private attorney though, but
All right, the clerk's telling me you have a okay, so it looks like it's Jay Mancuso, is that right?
I believe so, Your Honor.
All right, so they say you already have a private attorney in this case, so they will continue to represent you. You're here because you have a capias from Polk County case number 2026 CF 1081, and the 3 counts associated with that for failure to appear at the pretrial conference. I have reviewed are you wanting to go forward today, or are you going to, or do you want to wait to have this hearing tomorrow when your attorney can be here?
I can wait till my attorney to be here.
All right, it's your responsibility to contact your attorney to let them know to be here tomorrow, okay?
Then I can't do that, then. I can't contact him.
All right, are you wanting to go forward today?
Yes, ma'am.
All right, I have reviewed the capias. I do find probable cause for all the charges. The judge who issued the capias set your bond at $15,000 on each count, so that's the situation. You'll have a pretrial conference hearing on this case on August the 27th at 8:30 a.m., okay?
Yes, ma'am.
That count 3 is 5,000. Is it 15 on all of them?
Hang on one second. Let me look. Let me make sure I didn't see the wrong figure when I was going through.
Damn, that's high.
The clerk is saying something else. Let me look at it again, because it makes a big difference. All right, count 1, 15, count 2, 15, and the clerk is right, the third count on the criminal mischief over 200, that bond's not 15, it's 5,000, okay? Thank you very much. All right, thank you for that clarification. Thank you, sir. All right, moving on to Robert Drace. And I'm going to have a question about this one. All right, Mr. Drace, you're charged with possession of cannabis under 20 grams, and at least, it's not on my docket, but the arrest report has a second charge of use or possession of drug paraphernalia. So I'm asking the court personnel, everybody in the courtroom, was he booked in on that second charge, or was it just accidentally left off the docket?
They found probable cause on that other count yesterday. And so he was brought back to find probable cause.
Okay, so it's just, so sorry, nobody told me it was a bring back. So, all right, so you're just here on the possession of cannabis under 20 grams, is that correct?
No, ma'am. It should be the paraphernalia. There was no cannabis present. The officer,
hold on, sir.
it was supposed to be sorry.
Yeah. So the clerk's office,
We looked at it this morning. He came to first appearance yesterday. There were 2 charges. It was PDPC on that first count, and he was being brought back to give the state 24 hours for
the cannabis. All right, so the clerk's office is saying that how I said it is accurate. I was not here, but that is what the clerk's office is saying after they reviewed everything.
And the state has not received an amended affidavit at this time.
All right, the state has not received an amended affidavit after being given 24 hours. So on the cannabis charge, I'm going to release you on your own recognizance, sir, okay?
Thank you, ma'am.
Just remember, you've got an arraignment hearing set, and he already has counsel, right?
Yeah, he did yesterday.
Okay, I was just making sure you have counsel, and they're saying you did. You have an arraignment hearing set in the M5 division on August the 14th at 8:30 a.m. Thank you, sir.
Thank you, ma'am.
Hold on one second. No probable cause on the cannabis since the previous judge did not find it, and the state was given 24 hours to produce new information, and they did not. Thank you. All right, so that brings us to Timothy Hall. Mr. Hall, you are charged with 2 counts of violation of probation from Polk County case number 2024 CF 8050. Would you like for me to appoint the public defender's office to represent you, or are you going to hire your own attorney or represent yourself?
I've already hired a private attorney.
Okay, who is your private attorney?
DeMichael Law.
All right. So at least they haven't done a notice. They haven't put a notice of appearing, they have not filed a notice of appearance yet. The clerk's telling me that the clerk will note down that you're going to hire your own attorney, okay?
Yep.
Are you wanting to go forward with this today, or are you wanting to come
Yes.
back?
We can go forward today.
I have reviewed the arrest report. I do find probable cause for the charges because they're VOPs. Your bond status is no bond, but you'll have an arraignment on those VOPs in the F7 division on August the 25th at 8:30 a.m.
Judge, that count 2 was previously terminated according to the last 2 snap outs in the file.
Count 2?
Yes.
So are you talking about the harass or the second one?
That one was only 12 months and the other one I think was 36 or so.
Okay, so let me back up then. So I do find probable cause on the first count of violation of probation. What says the state and the defense? Because the clerk is saying that that probation was terminated on count 2.
What does that mean exactly?
It means that you might get ROR'd on the second count.
Okay.
So give them a minute to look at it and we'll see. And I don't have my computer or I would look it up, but.
What's the date, Cameron, on that? Well, the correction was done on February 14th. And that shows that it was 12 months probation. And then on the other, the most recent memos are all crossed out. That one.
So it's showing that it was 12 months probation on that count, and then the last 2 snap outs have it crossed off. The last one says it was previously terminated.
Not snap out?
Yeah,
No, well,
it's like all the way at the bottom. The top it's crossed off, it says pre-termed.
So that's the snap out dated that's the snap out dated March the 30th of 2026 at the top. That second count is crossed through and it says pre-terminated. Is that the state's position as well?
I am unable to locate that snap out, Your Honor. However, looking at the probation website, just based upon when he was placed on probation on the 12-month count, we are past that date.
All right, so you agree he should be ROR'd on that second count?
Yes, Your Honor.
All right, so Mr. Hall, as to the second count, I do not find probable cause, and the state is not requesting 24 hours, correct?
Correct, Your Honor.
All right, so you will be released on your own recognizance on that second charge, okay?
Uh-huh.
All right, and you don't forget that arraignment hearing on August the 25th at 8:30 a.m. Thank you, sir. All right, let's go on to Jaheim Kerrigan. All right, sir, it looks like you're charged with 18 counts of violation of probation out of Miami-Dade County. But I cannot appoint a Polk public defender because they are Miami-Dade counts. Once you get back to Miami-Dade, you can certainly ask the judge there to consider appointing the public defender to represent you if you qualify, okay?
Yes, ma'am.
All right, I have reviewed the arrest report. Did you find probable cause for the charges? Your bond status at this time is no bond, and if Miami, does he have another, oh, there we go. If Miami-Dade hasn't picked you up by August the 6th and you're still in our custody, then we'll bring you back to first appearance here, okay?
Yes, ma'am.
Thank you, sir. Okay, James Humphreys. Mr. Humphrey, you're charged with violation of probation out of Polk County in case number 2025 CF010261. Would you like for me to appoint the public defender's office to represent you?
Yes, ma'am. I have a question.
Hang on one second.
Yes,
I'm
ma'am.
hearing for the first time that you're a bring back. You weren't on my bring back list. So he was here yesterday or
Yes,
he?
ma'am. Yesterday, and this is an add-on, and he has the PD already appointed.
Okay, so an add-on, what do you mean, what's being added?
It says add-on VOP, but no, I can't remember the charge.
So it's the VOP I was reading out?
Yes, Judge.
Okay, all right. All right, that's what I thought we were here for, but excellent. So, but you already have the public defender?
I think so. I had asked yesterday for one.
So yes, yes. All right, so the clerk is saying, yes, you're already appointed a public defender. All right,
Is
so
this-
on that violation of probation from Polk County case number 2025 CF 010261, I have reviewed the VOP warrant and the affidavit of violation of probation. I do find probable cause for the charge. Your bond status is no bond, and you'll have an arraignment hearing on that VOP in the F7 division on August the 24th at 8:30 a.m. All right?
Yes, ma'am. I
Sir.
have one more question.
Yes, sir.
Is that an additional VOP to the one I had yesterday, or just one VOP?
I wasn't here yesterday, so I don't know. I only saw this one, but that
Yes,
doesn't
ma'am.
mean there isn't something else. That just means that's all the paperwork they gave me. All right, so next we have Willie Knighton. And after that is going to be Christopher Lewis. All right, Mr. Knighton, you're charged with resisting or obstructing an officer without violence. Would you like for me to appoint the Public Defender's Office to represent you?
Yes, ma'am.
I provisionally appoint the Public Defender's Office to represent you in this case. I have reviewed the arrest report. I do find probable cause for the charge. In this case, I'm going to require a straight bond in the amount of $1,000, and you have an arraignment hearing set in the M5 division on August the 14th at 8:30 a.m., okay?
Okay.
Thank you, sir. Christopher Dwayne Lewis. My understanding is this is a bring back, is that correct?
Yes, Judge, he completed his local charges and he has a hold for Orange County.
Okay. So, Mr. Lewis, you're here because you've got 2 counts of violation of probation from Orange County. They cannot appoint a public defender to represent you because it's Orange County charges. I have reviewed the arrest report. I do find probable cause for the charges. Your bond status is no bond. If you are still in our custody and Orange County hasn't picked you up by August the 6th, then we'll bring you back here to first appearance, okay?
Yes, ma'am.
Thank you, sir. Good luck. Moving on to Daniel Maldonado. All right, Mr. Maldonado, you are charged with trafficking in fentanyl over 4 grams, and pretrial services also notes that you have an open case in case number 2026 CF 1594. But as to this new charge, would you like for me to appoint the Public Defender's Office to represent you, or are you going to hire your own attorney or represent yourself?
No, I would like a public defender, ma'am.
I provisionally appoint the Public Defender's Office to represent you in this case. I have reviewed the arrest report. I do find probable cause for the charge, and I see the Assistant State Attorney is at the lectern.
Yes, Your Honor, may I approach?
You may.
Your Honor, this is a motion for pretrial detention. Just to give Your Honor some insight as to this case, and the facts behind it or circumstances are a little different than most of the motions that are normally filed. This case is currently in front of Judge Ramirez in Felony Division 4. There was an amended arrest, or there was an amended affidavit that was sent in along with an arrest warrant that changed one of the counts from the possession of fentanyl to a trafficking in fentanyl. I have endeavored to try and get in contact with Judge Ramirez's JA to see if we can get the motion for pretrial detention set in front of her. This case has been in front of her since approximately March of this year. However, at this time, I have been unable to reach her. I received an out-of-office email from one of automated bounce backs. So at this time, Your Honor, State is requesting that should Your Honor find this motion to be legally and facially sufficient, that this the motion be set just on the standard A2 docket at this time, and I believe that would be for August 3rd,
Yes, sir.
next week.
All right.
Do you need him to repeat?
Can you pull up the, hold on a second, it sounds like maybe ECR couldn't hear you, so hang on.
He just needs to speak up, and they said it's picking up on this mic. They don't think something is on, so he needs to stop.
You're gonna need to speak up because ECR isn't picking you up over there for some reason, so that mic may not be working, so you're gonna have to project.
Okay, I apologize, I think my voice is starting to go.
All right.
So, and I've spoken with defense on this. Instead of setting this for August 3rd, could we set this for next Thursday, August 6th? I don't know who is handling the pretrial detention motions next week on the A2 docket, but it may be Judge Ramirez, and this may give our office some time to potentially schedule with Judge Ramirez's JA and just see, if there's a chance that we can get this docket.
All right, so Mr. Maldonado, basically the state has handed me a motion for pretrial detention, and they are asking that you be held no bond on this case. The rest of what you heard was them trying to figure out if after I review their motion, I find it legally sufficient, they're trying to figure out when a hearing would be set for after this hearing. And so they were just kicking around some dates, but let me review the state's motion real quick. All right, I have reviewed the state's motion for pretrial detention, and I do find it legally sufficient. In this case, I have reviewed the arrest report. I do find probable cause for the charge. So at this time, your bond status is no bond. However, you will have a hearing in the A2 division on August the 6th at 1:00 p.m. Is there anything anyone wants to tell me about the open case, 2026 CF 1594?
At this time, Your Honor, I am unsure if Parker would apply based upon the case number that is on the motion.
With the dates, because you had the big time lapse from the...
Well, I'm not sure if it's a new case or if they're going to just be amending the charge on the current case. So,
well, it sounds like we have nothing else to address at this time.
At this time, yes, Your Honor.
Thank you. Thank you, sir. Moving on to Christopher Moyers. All right, Mr. Moyers, you're charged with use or possession of drug paraphernalia, possession of cannabis over 20 grams, and driving while license suspended or revoked. Would you like for me to appoint the Public Defender's Office to represent you?
Yes, ma'am.
I provisionally appoint the Public Defender's Office to represent you in this case. I have reviewed the citation and arrest report. I do find probable cause for all the charges. I'm going to require pretrial release with bail's condition of pretrial release. Your bail is set at $5,000 on the felony cannabis charge, $1,000 on the paraphernalia charge, and $250 on the driving while license suspended or revoked charge. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone every week, 2 times a week on Tuesdays and Thursdays. You must submit to random urinalysis that you're required to pay for, and you are prohibited from driving without a valid driver's license. You have an arraignment hearing set in the A2 division on September the 1st at 8:15 a.m. Thank you.
I do have one question. You said the pretrial to commission the bail, so I just have to wait to get released, are you saying? Or I need to call a bondsman?
So you can do cash, or you can contact the bondsman. But
Okay.
that's up to you, okay?
All right, thank you.
Thank you. The next case is Jarquavia Markel O'Neill. Sir, you're charged with burglary of an unoccupied dwelling and grand theft $20,000, but less than $100,000. Would you like for me to appoint the Public Defender's Office to represent you?
Yes, ma'am.
I provisionally appoint the Public Defender's Office to represent you. I have reviewed the arrest warrant and the complaint affidavit. I do find probable cause for all of the charges. And I see our Assistant State Attorney is at the lectern. What would you like to tell me?
Yes, Your Honor, may I approach?
You may.
And Your Honor, this is a motion for pretrial detention as it relates to the burglary count. Should Your Honor find this motion to be legally and facially sufficient, the state would request a pretrial detention hearing set next Monday, August 3rd at 1 p.m. on the A2 docket.
All right, so Mr. O'Neill, the state is asking, they've filed a motion for pretrial detention on the burglary charge and are asking on that charge that I hold you no bond. I'm going to review their motion for legal sufficiency. there anything the defense wants to tell me?
Yes, Your Honor. In paragraph page 1, it says, based on the defendant's present patterns of behavior, no conditions would guarantee community. And at the same time, on page 2, it says, at this early time, it's unknown to the undersigned attorney whether the defendant has any open criminal cases, history, past failures, etc. I would argue that this is legally insufficient. I'd ask the court to deny.
What says the state?
Your Honor, this motion is filed pursuant to Florida State Statute 907.0415 under the dangerous crimes. Based on the motion under state, would argue that there is enough, to find this motion to be facially sufficient at this time. This is the same motion that's been filed 3 other times today. However, if I doesn't find this motion to be sufficient, state can request 24 hours from that.
All right.
Judge, this charge differs from the others in that it is an F2 and not the F1s we've been doing.
Yes, sir. I do find the motion to be legally sufficient. I am going to grant the state's motion for pretrial detention on the burglary charge. So right now your bond status is no bond on that burglary charge, but you'll be brought before another judge to decide whether or not your bond status should stay no bond, okay? And that hearing will be set for, that's Monday, right?
The 3rd.
Okay. All right, so you'll have a hearing on this on Monday, August the 3rd at 1:00 p.m. in the A2 division. As to the remaining charge, I'm going to require pretrial release with bail's condition of pretrial release. Your bail is set at $15,000. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone every week, twice a week on Tuesdays and Thursdays. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives, and you're prohibited from having any contact with the victims or the witnesses in this case. You may not contact the victims or witnesses directly or indirectly. You may not contact the victims or witnesses in any manner whatsoever. You must stay at least 500 feet away from the victims and witnesses, their residences, their vehicles, places of employment, and schools at all times. You've got in addition to the hearing I already told you about, you have an arraignment hearing set for August the 18th in the A2 division at 8:15, and it'll be on the paperwork that you get, okay? Thank you, sir. Noel Ortiz. Mr. Ortiz, you're charged with resisting or obstructing an officer without violence and domestic violence battery. Would you like for me to appoint the public defender to represent you in this case?
Yes, ma'am.
I provisionally appoint the public defender's office to represent you. I have reviewed the arrest report. I do find probable cause for the charges. In this case, I'm going to require pretrial release with bail's condition of pretrial release. Your bail is set at $5,000 on the domestic violence battery charge and $1,000 on the remaining charge. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone every week, 3 times a week on Mondays, Wednesdays, and Fridays. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives, and you're prohibited from having any contact with the victim in this case. You may not contact the victim directly or indirectly. You may not contact the victim in any manner whatsoever. You must stay at least 500 feet away from the victim's residence, vehicle, place of employment, and school at all times. I'm going to allow you a one-time return to the residence and one time only. However, that must occur within 48 hours of your release from custody, and you must be accompanied by a law enforcement officer. You also have an arraignment hearing set in the M5 division on August the 14th at 8:30 a.m. Thank you, sir. Vernon Ostrander. Sir, you are charged with use or possession of drug paraphernalia, tampering with physical evidence, keeping a public nuisance structure or conveyance for drug activity, trafficking and methamphetamine, over 14 grams, and knowingly driving while license suspended or revoked, third or subsequent offense. Would you like for me to appoint the public defender's office to represent you?
Yes, ma'am.
I provisionally appoint the public defender's office to represent you. I have reviewed the citation and the arrest report. I do find probable cause for all of the charges. And the assistant state attorney is at the lectern. Yes, sir. You may.
Your Honor, this is a motion for pretrial detention as it relates to the trafficking count. Should Your Honor find this motion to be legally and facially sufficient, State would request a pretrial detention hearing to be set next Monday, August 3rd, on the A2 docket.
All right, so the state's asking that I hold you no bond, because they filed a motion for pretrial detention. They're asking to hold you no bond on that trafficking charge. I'm going to review their motion for legal sufficiency. I have reviewed the motion. I do find it to be legally sufficient. As to all of the other charges, with the exception of the trafficking charge, I'm going to require a pretrial release with GPS electronic monitoring and bail as condition of pretrial release. You may not be released until the GPS electronic monitor is affixed to your person. Once you are released, you must report immediately to Pretrial Release Services Office in person in Bartow at 1745 South Highway 17. Thereafter, you must report by phone every week, 7 days a week, so every day of every week. You also must submit to random urinalysis that you're required to pay for. I'm imposing a curfew from 6 p.m. until 6 a.m., and you are prohibited from driving without a valid driver's license. Your bail is set at $1,000 on the drug paraphernalia charge. Your bail is set at $7,500 on the tampering with physical evidence charge. Your bail is set at $5,000 on each of the remaining charges, with the exception of the trafficking charge. On the trafficking charge, your bond status is no bond, but you will have a hearing on that matter to see if it should stay no bond. You'll have a hearing on that matter on August the 3rd at 1 o'clock p.m. in the A2 division. And you have an arraignment hearing for this case set for September the 1st at 8:15 a.m. in the A2 division. Thank you, Mr. Ostrander. Alonzo Patino.
Good afternoon, Your Honor.
Good afternoon, sir. You're charged with violation of probation from Polk County case number 2025 CT 3079. Would you like for me to appoint the Public Defender's Office to represent you?
Yes, please.
I provisionally appoint the Public Defender's Office to represent you in this case. I have reviewed the violation of probation warrant and the affidavit of violation of probation. I do find probable cause for the charge. Right now, your bond status is no bond, but you will have a hearing on August the 3rd at 12:45 p.m. in the M6 division, okay?
Yes, thank you.
Thank you. Is Andre Pittman, was he transferred?
No, ma'am.
He's here?
No.
He was removed from the docket.
Yes, ma'am.
Okay, so I don't know what the status, no one can tell me what the status is, so I don't know if he's supposed to be brought
All
up.
we were told was he transferred. That's the information we received. Well, no, it wasn't that he transferred. It was that yesterday nobody knew where he was either.
Well,
Because
that's,
there's two different,
Not gonna
there's this one, and then
They told me that he's not on the docket. He was removed from the docket.
I understand that, but. So is he in custody here or not?
Your Honor, I can check on it for you.
Okay, if you'll let me know, and then we'll come back to him, because I either have to, if he's there, he needs to be brought over. Because as I understand it, it's supposed to be a bring back, but if he's been transferred, then obviously, we don't have to bring him back, okay? So we'll circle back to him at the end.
Yes, ma'am.
All right, let's go to Giovanni Pruitt. All right, Mr. Pruitt, you're charged with misdemeanor possession of cannabis and driving while license suspended or revoked. Would you like for me to appoint the Public Defender's Office to represent you?
Yes, ma'am.
I provisionally appoint the Public Defender to represent you in this case. I have reviewed the arrest report. I do find probable cause for the charge. Please raise your right hand, sir. Do you swear or affirm testimony you provide today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You're 18?
Yes.
Are you in school, or are you working, or what are you doing?
I'm about to start working. I'm waiting for an orientation date.
Okay, and where are you going to be working at?
I'm working through a temp agency for Prologics for riders in Apaka.
Okay. Do you live in Polk County, or do you live outside of Polk County?
Yes, I live in Davenport.
All right. And are you still getting support from parents or guardians or anything?
Yes, I live with my parents.
Okay. In this case, I have reviewed the arrest report. I do find probable cause for the charges. I'm going to require on the DWSR bond in the amount of $250, and on the cannabis charge, I'm going to require a bond in the amount of $750. Once you are
Okay.
released, you must report immediately to pretrial release services office in person in Lake Alfred at 200 Government Center Boulevard. Thereafter, you must report by phone every week, 2 times a week on Tuesdays and Thursdays. You must submit to random urinalysis that you're required to pay for. I'm going to let you know that you have an arraignment hearing set in the M5 division for August the 14th at 8:30 a.m., okay?
Okay, I have a question.
Yes, sir.
As far as the urine testing and stuff, I'm in the process of getting my medical marijuana. Would that void anything with that, or no?
I'm not here to give you legal advice, but I know that pretrial services will talk to you, okay? And you
Okay.
certainly I have appointed your attorney, and they can talk to you about that too, okay?
Okay.
All right, thank you, sir, good luck. Scotty Rayner? All right,
Your
Mr.
Honor.
Rayner? Yes, sir?
They said Pittman bonded, Your Honor. Pittman bonded.
It already bonded out. I thought it was a VOP,
It is a VOP.
so how could he bond out?
A warrant must be VOP for Highlands.
I guess my question is, how did he bond out on a VOP? That I thought Highlands had it, no bond.
We'll look back at it, Your Honor.
Okay, let me know. Thank you, I appreciate you looking into that. All right,
Yes,
Scotty
ma'am.
Rayner?
Yes, ma'am.
Mr. Rayner, you're here on 2 counts of violation of probation from Polk County case number 2025 CF 011431. Would you like for me to appoint the public defender's office to represent you?
Yes.
Provisionally appoint the public defender's office to represent you. I have reviewed the arrest report. I do find probable cause for the charges. Because they're VOPs, your bond status is set at no bond at this time, but you'll have a VOP arraignment hearing on August the 25th at 8:30 a.m. in the F7 division. Thank you, Mr. Rayner. All right, that brings us to Christopher Smith. All right, Mr. Smith, you're here because you have warrants out of Marion County for violation of probation on a giving false name charge. And Marion County has your bond set on that VOP at no bond. And you're also here on a driving while license suspended or revoked charge out of Marion. And Marion has that bond status set at no bond. Cannot appoint a Polk public defender to represent you since they are not Polk charges. But I have reviewed the arrest report and the warrant confirmation teletype. I do find probable cause for the charges. If you are still in Polk's custody on August 6th, then you'll be brought back here for first appearance, okay?
Yes, ma'am.
Thank you, Mr. Smith.
Thank you.
All right, that brings us to Sebastian Trim. All right, Mr. Trim, you're charged with 4 counts of violation of probation from Polk County case number 2022. Is this a Polk County case? I didn't write it down.
Yes.
Polk number 2022 CF 91808. Would you like for me to appoint the public defender's office to represent you?
I should have a lawyer.
Are you showing any attorney still on the case? Sometimes at the conclusion of the case, the original case, then the attorneys come off. But we'll see here.
Should be John Lagori.
But he had,
On the probation yet.
he hasn't filed anything, so he was on your original case like I was talking about, but he hasn't filed anything since this is basically kind of a new charge, their violation of probation. So he hasn't entered a notice of appearance yet. Are you going to be hiring him?
Yes, ma'am.
You are going to be hiring him?
Yes, ma'am.
All right. So the clerk will note that you're going to hire an attorney on this matter. Are you wanting to go forward with this today, or do you want to be brought back tomorrow and you can contact your attorney?
We go forward today.
All right. I have reviewed the arrest report. I do find probable cause for all the charges because they're VOPs. Your bond status is no bond, but you'll have a hearing on August the 3rd at 8:30 a.m. in the F6 division, okay? Thank you, Mr. Trim.
Thank you.
Donovan Vinson, and I'm going to have a question about where the jurisdiction is on this VOP.
Yes,
All right, Mr. Vincent, you're charged with violation of probation, underlying charge of grand theft, and I think the clerk's office is letting me know it's out of Hillsborough County. So I cannot appoint a public defender to represent you. When you get over to Hillsborough County, you can certainly ask the judge to consider appointing the public defender's office if that's your desire and you qualify, okay?
Okay.
All right, I have reviewed the arrest report. I do find probable cause for the charge. So your bond status is at no bond because it's a VOP. And if Hillsborough hasn't picked you up and you're still in our custody on August 6th, then we'll bring you back here to first appearance, okay?
Okay.
Thank you, sir. Thomas Van Roo.
On, Rob.
Van Rob, you are charged with domestic violence battery. Would you like for me to appoint the public defender's office to represent you, or you can hire your own attorney or represent yourself?
Public defender, but can I ask a question?
Well, hold on, let's go through the things I got to go through first. I provisionally appoint the public defender's office to represent you. I have reviewed the arrest report. I do find probable cause for the charge. Yes, sir.
Uh-huh. Yes. I do want the public defender. But,
Okay, I already appointed them.
can I ask a question?
I already said yes, sir.
Okay, my sister was supposedly brought down here, the alleged person that domestic violence, and signed affidavit to non-prosecution and to judges.
So I have no way of knowing if that occurred, but just so you know, that doesn't affect what I do today.
No, I know. I don't know how this thing works.
Okay.
It's my first.
Client to remain silent.
All right, so the public defender, the assistant public defender is asking that you remain silent. He's trying to make sure he protects your rights, okay?
Yeah, okay, I'm sorry. Apologize.
That's all right. No, that's all right. All right, I have reviewed the arrest report. I do find probable cause for the charge. In this case, I'm going to require a pretrial release with bail as the condition of pretrial release. Your bail is set at $5,000. Once you are released, you must report immediately to Pretrial Release Services office in person in Lake Alfred at 200 Government Center Boulevard. Thereafter, you must report by phone every week, 3 times a week on Mondays, Wednesdays, and Fridays. You are prohibited from having any contact with the victim in this case. You may not contact the victim directly or indirectly. You may not contact the victim in any manner whatsoever. You must stay at least 500 feet away from the victim's residence, vehicle, place of employment, and school at all times. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. I'm going to allow you a one-time return to the residence and one time only. However, it must occur within 48 hours of your release from custody, and you must be accompanied by a law enforcement officer. The purpose for that one-time return is for you to quickly gather essential items, things such as medication, clothing, work tools, important paperwork, things of that nature. You have an arraignment hearing set in the M5 division on August the 14th at 8:30 a.m. Thank you, sir.
One more thing. That building that my sister's resident is owned by me and my wife, and she's moved.
Sir, if you can remain silent, we'll deal with it. Thank you.
Okay. But she said I can't go to my own house.
All right, moving on to Anthony Williams.
Yo, he couldn't make it due to medical reasons. Can we bring him back tomorrow?
Yes, sir, let's bring him back tomorrow if he's able to come. All right, let's move on to Damon Wilson. All right, Mr. Wilson, you are here because you have some KPSs out for you for failure to appear at mandatory docketing call hearings for Polk County case numbers 2026 MM 2736, 2026 CT 2733, and 2026 CT 2732. Would you like for me to appoint the public defender's office to represent you?
Yes, ma'am. I already had a public defender on that case, and I was incarcerated in Hillsborough, so that's why I was unable to attend the court date, which I have the valid driver license.
All right, and that's certainly something you can present to your attorney to help you out with, okay? But just so that the record's very clear, just in case the record doesn't reflect the public defender's office being appointed, I do provisionally appoint them to represent you on these cases. The judge, I have reviewed the KPSs. I do find probable cause for all of the charges. Right now, the judge who issued the KPS has your bond status at no bond. So you will go for a pretrial conference hearing on September the 2nd at 8:30 a.m. in the M6 division, okay? All right, and I did appoint the public defender's office, so you can certainly talk to them and see if they can move up any hearings, okay? All right, thank you. I see a gentleman in the back, and I'm not sure who that is. If y'all can tell me who it is, let's see what's the situation.
Joseph Snyder.
Snively?
Snyder,
Joseph Snyder.
Joseph Snyder.
Okay, hold on one second. Joseph Snyder. I don't have that, but let me just.
Snyder Joseph.
Snyder, I was told that it came off, right? I thought.
Judge, I believe the info we had about this was that.
I think they got first name first on
I don't think he was.
They got first name first on there.
My last name is Joseph.
What's your?
It's under last name
They got.
Joseph.
Oh,
Okay,
okay.
hang on. Y'all hang on one second.
It could be backwards on the docket, but it's under Joseph.
South. Yeah. Okay.
Pull up on the screen here.
All right, I'm just trying to find on my docket.
Tomorrow.
It's listed on the docket, Joseph.
Joseph,
First name is Snyder Joseph.
Schneider Joseph, okay, so that might be backwards. All right, so sir, you've got 4 counts of violation of probation out of Palm Beach County, and at least we were told you were being transferred tomorrow. So you do have violations of probation. I cannot appoint a Polk public defender to represent you because they're Palm Beach County charges. But I have reviewed the arrest report, and I do find probable cause for all of the charges. If you are still in our custody, we've heard that Palm Beach is going to come get you tomorrow, but if you're still in our custody on August the 6th at 1 p.m., you'll be brought back here to first appearance, okay?
Okay.
Thank you, sir. All right.
Your Honor, back on Pittman, he
Yes,
was
sir.
transferred to South County. He did not bond.
All right, so I guess he needs to be brought back, because at least as I understand it, those charges haven't been addressed. Is that correct? He was supposed to be brought back?
Yes.
All right, so let's bring him back tomorrow, okay?
Yes, ma'am.
All right, and then I'll probably be asking everybody about the jurisdiction.
Good job.
Good morning, I'm hearing examiner Mike Singer. Today is Thursday, July 30th, 2026. Can the board members please state your name for the record?
Jennifer Zaccanini. Amy Keys.
Alex Tucker.
This is a final revocation review for Kareem Mayo, number 210552. Steel Menard recommends a revoke and repro date of 4/19/2027, approximately 10 months sanction with the following conditions. Halfway house placement, no contact with co-defendant Michael Carey, no contact with victim YG, strict no drive, no alcohol consumption, mental health evaluation, treatment deemed necessary, and a general contact with ND without PO's permission. The board accept or reject this recommendation.
Ms. Keys? I accept. Okay, Mr. Zarko?
I did too.
So, I'm not sure, I really couldn't find a reason for the strict no driving. What are your thoughts? We typically don't use that. I know his last violation involved motor vehicle stuff and he has a DUI in his instant offense, but I try to leave that up to the field officer so they don't have to come back with a case review. Should he, he's got special parole till 2031. So if he could get his act together and get an interlock ignition device and get his license, I don't know. What are your thoughts?
And it was not recommended by community advisor.
Well, it was already on there. It was already conditioned from the previous release, but I don't know.
Did we do no driving without
Without the prosecutor's permission, yeah.
Yeah.
And I thought we did away with the strict no driving condition when we revamped our conditions. All right. So in the matter of Kareem Mayo, number 210552, I'll move to accept the recommendations of the hearing examiner and revoke special parole with the recommended conditions, but we'll modify the strict no driving to a no driving without the parole officer's permission. Is there a second?
Second.
All in favor? Aye.
Who's by review for Kareem Mayo, 210552. Good morning, hearing examiner Mike Singer. Today is July 30th, 2026. Can the board members please state your name for the record?
Jennifer Zaccanini.
Amy Keys.
Alex Tucker.
This is a final revocation review for Joanberto Rivera for 416190. P.O. Menard recommended a revoke with a repro date of 8/24/2026, which struck a 5-month sanction with the following conditions: behavior management program for domestic violence and no contact co-defendant Brian Escaccio, Rafael Davia, and Luis Davia. And no operation with motor vehicle without PO's permission. Does the board accept or reject this recommendation?
Mr. Zarko?
Accept.
Ms. Keys?
I accept.
I do want to say for the record and for the field that we could not find the new victim's name anywhere because it is it's redacted from all the reports. So if you have that name and you want to send it back for a case review to add that condition, we'd be happy to do so. In the matter of Joanberto Rivera, 416190, I'll move to accept the recommendation of the hearing examiner. Is there a second?
Second.
All in favor?
Aye.
Aye.
Who's by review for Rivera, 416190. Good morning, hearing examiner Mike Singer, July 30th, 2026. Can the board members please state your names for the record?
Jennifer Zaccanini.
Amy Keys.
Alex Tucker.
This is a final revocation due for Ayala Jonathan, number 385595. I recommend a revoke with a repro date of September 23rd, 2026, with the following conditions: halfway house placement, general no contact with Joseph Lockwood and LG without PO's permission, no contact with co-defendant Elijah Stanford and Alexis Rhea, mental health evaluation can be necessary, operation motor vehicle, your management program for domestic violence. And I did want to note, there's also general no contact with Sean Ross and a no contact with co-defendants Javon Clay and Tesha.
News. Yep.
This board accept or reject this recommendation.
Okay. Ms. Keys?
I accept.
Mr. Zarko?
I accept.
Okay, in the matter of Jonathan Ayala, 385595, I'll move to accept the recommendations of the hearing examiner. Is there a second?
Second.
All in favor?
Aye.
Aye.
This includes finding for Ayala, number 385595. Good morning, hearing examiner Mike Singer, today is July 30th, 2026. Please state your name for the record.
Jennifer Zaccanini.
Amy Keys.
Alex Tucker.
This is a final revocation review for Friesen Cosmo, number 331010. I recommend a revoke with no new hearing date, a special parole completion date of 10/15/2026, which is a 7-month and 27-day sanction. Does the board accept or reject this recommendation?
Mr. Zarko?
Accept.
Ms. Keys?
I accept.
All right, in the matter of Cosmo Friesen, I don't know, 331010, I'll move to revoke special parole with no new date. Is there a second?
Second.
All in favor?
Aye.
Aye.
This includes the final review for Friesen, number 331010. Good morning, Attorney Examiner Mike, here today, July 30th, 2026. Can the board members please state your names for the record?
Jennifer Giacomini. Julie Keys.
Alex Sacco.
This is the final revocation review for Nancy Frederick, number 333358. I recommend a revoke with the repro date September 10th, 2026, with the following conditions: no consumption of alcoholic beverages, mental health evaluation should be deemed necessary, general no contact with TD Bank, 623 Rocky Hill, Connecticut, and TD Bank, 1127 Farmington Ave. Does the board accept or reject this recommendation?
Mr. Zarka.
I accept.
Ms. Keys. I accept. All right, in the matter of Frederick Johansson, 333358, I'll move to accept the recommendations of the hearing examiner. Is there a second? Second. All in favor?
Aye.
Aye.
This is the second for Johansson. 3358. Good morning, Attorney Examiner Mike here, today, July 30th, 2026. Can the board members please state your names for the record?
Jennifer Giacomini. Julie Keys.
Alex Sacco.
This is a final revocation review from McCray Sean, number 350537. I recommend a revoke with no hearing date with an EOS date of 11/18/2026, which is a 6-month and 10-day sanction. Does the board accept or reject this recommendation?
Ms. Keys. I accept. Mr. Zarka.
I do too.
In the matter of Sean McCray, I'll move to accept the recommendation of the hearing examiner, revoke with no new date. Is there a second? All in favor? Aye.
Include McCray, number 350537. Good morning, Attorney Examiner Mike here, today, July 30th, 2026. Can the board members please state your names for the record?
Jennifer Giacomini. Julie Keys.
Alex Sacco.
This is a final revocation meeting for Oliver Lamont, 382276. I recommend a revoke with a repo date of 7/30/2026 with the following conditions: no consumption of alcoholic beverages, behavior management program for domestic violence, general no contact with SRF, no contact with co-defendants Ricky Jordan, Luis Perez, and Rennie Stone, no contact with victims Sam's Convenience Store, 55 Oakland Street, Manchester, Lucky's Convenience Store, 42 Oak Street, Manchester, Quick Mart, 1 Broad Street, Manchester, Sunoco Gas Station, 484 East Middle Turnpike, Manchester, and Lynn Garden, 846 Main Street, Manchester. Does the board accept or reject this recommendation?
Mr. Zarka.
I accept.
Ms. Keys. I accept. All right, in the matter of Lamont Oliver, I'll move to accept the recommendations of the hearing examiner. Is there a second? Second. All in favor? Aye.
This I move for Oliver for 38276. Good morning, Attorney Examiner Vice here, today, July 30th, 2026. Can the board members please state your names for the record?
Jennifer Giacomini. Julie Keys.
Alex Sacco.
This is a final revocation review for Staples Belmont, number 241014. I recommend a revoke with a repro date of February 9th, 2027 with the following conditions: halfway house placement, no consumption of alcoholic beverages, mental health evaluation should be necessary, and no contact with co-defendants Brian Straught and Jennifer Scanlon. Does the board accept or reject this recommendation?
Excuse. I accept. Mr. Zarka.
You too.
All right, in the matter of Delmont Staples, I'll move to accept the recommendations of the hearing examiner. Is there a second? Second. All in favor? Aye.
This includes my name for Staples, number 241014. Good morning, July 30th, 2026. Can the board members please state your names for the record?
Jennifer Giacomini. Julie Keys.
Alex Sacco.
This is a final revocation due for Topar Edward, number 405078. I recommend a revoke with the repro date of January 20th, 2027 with the following conditions: general no contact with EB, no contact with victim LB without PO's permission, behavior management program for domestic violence. Does the board accept or reject this recommendation?
I don't know why I had a halfway house, probably because you had it before. I know he's got a friend as a proposed sponsor. Should we put it in case it's new? Yeah. All right, Mr. Zarka?
Accept.
Ms. Keys? All right, in the matter of Edward Topier, I'll move to accept the recommendations of the hearing examiner. We'll add a halfway house condition if it's needed. Is there a second? Second. All in favor? Aye.
This includes final review for Topar 5078. Good morning, Attorney Examiner Mike here, today, July 30th, 2026. Can the board members please speak your name for the record?
Jennifer Giacomini. Julie Keys.
Alex Sacco.
This is a final revocation review for Young Cedric, number 250030. I recommend a revoke, the repro date of February 16th, 2027 with the following conditions: halfway house placement, no consumption of alcoholic beverages, mental health treatment, medication compliance, and operation of motor vehicles. Does the board accept or reject this recommendation?
Ms. Keys? I accept. Mr. Zarka?
I accept.
All right, in the matter of Cedric Young, I'll move to accept the recommendations of the hearing examiner. Is there a second? Second. All in favor? Aye.
This includes my review for Young, number 250080.
Good morning, I'm hearing from Examiner Chisella. Today is Thursday, July 30th, 2026. Board members, please state your names for the record.
Jennifer Zaccanini. Elaine Keith.
Alex Sokol.
This is a final revocation review for Anthony Abraham, and number 449668. I recommend a removal from parole on July 30th, 2026, which is an approximate 4-month sanction with the following condition. No contact with co-defendants Stephen Sorbo, Drazen Robinson, Christopher Spears, and Asim King. This board accept or reject this recommendation.
Ms. Keys? I accept. Ms. Shuttleworth. Okay, in the matter of Anthony Abraham, I'll move to accept the recommendation of the hearing examiner. Is there a second? Second. All in favor? Aye.
Move for revocation review for Abraham, and number 449668. Good morning, I'm hearing the Examiner Chisella. Today is Thursday, July 30th, 2026. Board members, please state your names for the record.
Jennifer Zaccanini. Elaine Keys.
Alex Sokol.
This is a final revocation review for Gary Kenyon, and number 209557. I recommend a revoke and referral on October 2nd, 2026, which is an approximate 6-month sanction with the following conditions. No consumption of alcoholic beverages, a general no contact with MR, mental health evaluation treatment as deemed necessary, and no operation of a motor vehicle without parole officer's permission. This board accept or reject this recommendation.
Accept.
Ms. Keys? I accept. Okay, in the matter of Gary Kenyon, I'll move to accept the recommendations from the hearing examiner. Is there a second? Second. All in favor? Aye.
This concludes the final revocation review for Gary Kenyon, and number 209557. Good morning, I'm hearing Examiner Chisella. Today is Thursday, July 30th, 2026. Board members, please state your names for the record.
Jennifer Zaccanini. Elaine Keys.
Alex Sokol.
This is the final revocation review for Jean Louise Finn, inmate number 401056. I recommend a revoke and reparole on July 30th, 2026, which is an approximate 4-month sanction with the following conditions. Behavioral management program for anger management, no contact with victims JP and KM, and in general, no contact with SJL without parole officer's permission. Does the board accept or reject this recommendation?
And the police report, the initials for SJL were actually JSL. And I have the date of birth. So, and then I have the cousin's initials who's also present, but not.
Sorry.
But yeah, but I don't know if you correct the initial order. It was said several times out there, but the board is JSL.
I think I confirmed it on his DOC.
Yeah. The visitor list.
The visitor list, but, and I asked him in the hearing too, but I can whatever order you guys want to do, or to do both, if that.
Oh, do both?
Could be wrong in the police report.
Yeah.
Whichever way you guys are.
Right, but it's you're gonna have to write it out. So.
This AKA JSL.
Okay, all right. In the matter, any objections to this?
No objection.
Okay. In the matter of Jean Louis Finn, I'll move to accept the recommendation of the hearing examiner. And for the general no contact, we'll use SJL, AKA JSL. Is there a second?
Second.
All in favor?
Aye.
This concludes the final revocation fee for Jean Sen and for 401056.
Bye, darling.
Yeah.
Good morning, I'm Darren Chisella. Today is Thursday, July 30th, 2026. Board members, please state your names for the record.
Jennifer Zaccanini.
Elaine Keys.
Alex Sokol.
This is final revocation for Michael Pacheco Rodriguez, inmate number 372435. I recommend a revoke and referral on July 30th, 2026, which is an approximate 3-month sanction with the following conditions. No consumption of alcoholic beverages, behavioral management program for anger management, no contact with co-defendant Francisco LaBoy, no contact with victim HO, a general no contact with MP without parole officer's permission, and halfway house placement. This board accept or reject this recommendation.
Mrs. Zarka?
Accept.
All right, in the matter of Michael Pacheco Rodriguez, I'll move to accept the recommendations of the hearing examiner. Is there a second?
Second.
All in favor?
Aye.
It's a final revocation fee for Michael Pacheco Rodriguez, inmate number 372435. Good morning, I'm here. Sarah Chisella. Today is Thursday, July 30th, 2026. Board members, please state your names for the record.
Jennifer Zaccanini.
Elaine Keys.
Alex Sokol.
This is the final revocation fee for Leonard Singleton, inmate number 376969. I recommend a revoke and referral on October 23rd, 2026, which is an approximate 6-month sanction with the following conditions. No consumption of alcoholic beverages, behavioral management program for domestic violence, no contact with co-defendants Ricky Williams, Samuel Miller, and Alana Rivera. A general no contact with victims LR, MC, AC, and OR. A general no contact with SS, NF, GM without parole officer's permission. Does board accept or reject this recommendation?
Ms. Keys?
Okay, did you say NF and H? Or
NH.
sorry.
I'm sorry.
NA, yeah.
Sorry.
I accept, but I almost just wanted to have him warned that he could, you know, that if he does anything like this again, he can be held until 2031. This sounds behavior offensive.
Mhm.
So I'm sure you guys have reminded him, but if there's another incident like this and just waiting programming relevant to his offenses, can be held till 2031.
Mr. Zucker?
I'm in favor.
I accept the recommendation.
Okay, in the matter of Leonard Singleton, I'll move to accept the recommendations of the hearing examiner. Is there a second?
Second.
All in favor?
Aye.
This concludes the final revocation fee for Leonard Singleton, 376969. Good morning, I'm here to examine Trisella. Today is Thursday, July 30th, 2026. Board members, please state your names for the record.
Jennifer Stephanie?
Julie Keys.
Alex Sarkoff.
This is a final revocation fee for Daniel Wisnat, inmate number 253715. I recommend a revoke and re-parole on December 10th, 2027, which is an approximate 18-month sanction with the following conditions: no alcoholic beverage consumption, no contact with victim SW, mental health evaluation, no contact with minors, problem sexual behavior treatment, and halfway house placement. Does the board accept or reject this recommendation?
Mr. Zarka?
Accept.
Ms. Keys?
Accept.
All right, in the matter of Daniel Wisnant Jr., I'll move to accept the recommendations of the hearing examiner. Is there a second?
Second.
All in favor?
Aye.
Aye.
This concludes the final revocation fee for Daniel Wisnat, inmate number 253715. Morning. To sell on today's Thursday, July 30th, 2026. This is a case of you to add a stipulation for day long. John, number 264362 at the Connecticut Board of Pardons and Parole. Members, please state your names for the record.
Jennifer Stephanie?
Julie Keys.
Alex Sarkoff.
Parole and Community Services has requested to add the no consumption of alcoholic beverages stipulation, and at this time, the panel will deliberate.
Any objection?
No.
All right, I'll move to add no alcohol to its existing conditions. Is there a second?
Second.
All in favor? Aye.
This completes the case in here for daily Cruz and the number 364362. Good morning. My name is Parole Officer Trisella, and today is Thursday, July 30th, 2026. This is a board review to add a stipulation for Christopher Jackson, inmate number 349303 at the Connecticut Board of Pardons and Paroles. Board members, please state your names for the record.
Jennifer Stephanie?
Julie Keys.
Alex Sarkoff.
Parole and Community Services has requested to add a no contact with co-defendant Shivane Campbell condition stipulation. At this time, the panel will deliberate.
Any objections?
No objections.
Okay, so, Officer Trisella, if you could just verify the spelling, because we believe the spelling of his, first name is wrong in the field's request. The police report has it spelled out.
BHA instead of CHE.
AME. I'll double check the police report.
Thanks. In the matter of Christopher Jackson, I'll move to add, no contact with co-defendant Shivane Campbell to his existing conditions. Is there a second?
Second.
All in favor?
Aye.
Aye.
This is a case of hearing for Christopher Jackson. Good morning. My name is Parole Officer Trisella. Today is Thursday, July 30th, 2026. This is a case of you to add a stipulation for Lawrence LeGray, inmate number 313283 at the Connecticut Board of Pardons and Paroles. Board members, please state your names for the record.
Jennifer Zaccanini?
Julie Keys.
Alex Sarkoff.
Parole and Community Services has requested to add the half house placement stipulation, and at this time, the panel will deliberate.
I'll move to add the halfway house condition to his existing steps for Lawrence LeGrave. Is there a second?
Second.
All in favor?
Aye.
Aye.
Case
Good morning, Mr. Christopher.
Good morning.
You can hear us okay?
Yes.
Okay, we're gonna get started, all right?
All right.
Good morning, I'm P.O. Meisinger, here an examiner for the Board of Pardons and Paroles. Can the board members who are present today please state your names for the record?
Good morning, I'm Jennifer Zaccanini.
Good morning, Amy Keys.
Morning, Alex Tarkov.
This is the rescission hearing concerning Christopher J. Beyond, number 438763, today is July 30th, 2026. This hearing is being conducted at McDougal Walker Correctional Institution in the BOPP Central Office via video. This is a public hearing and public access to the hearing is available via video live stream. Can you please state your name and inmate number for the record, sir?
Javion Christopher, 438763.
This is a rescission hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. If I find you violated one or more conditions of your release, the board will consider whether or not your release should be rescinded. The decision made by the board today will be final. This is an administrative hearing. The rules limiting the type of evidence admissible in a criminal trial do not apply in a parole rescission hearing. Disputed charges will be resolved by the preponderance of the evidence. The preponderance of the evidence means evidence that taken as a whole is more credible and convincing than the evidence offered in opposition to it. If at any time during the hearing you have a question about the procedure, feel free to ask me about it. At this hearing, you have certain rights, which I'm going to now review with you. Did you receive the written notice of the hearing?
Yes.
Did you receive a packet of information which includes the rescission notice and the information supporting the charges against you?
Yes.
You have the right to be represented by an attorney at this hearing. You may retain your own attorney. If you cannot afford an attorney, there are limited circumstances under which one may be appointed for you by the board. Do you want to proceed without an attorney?
Can you repeat that again?
Do you want to proceed without an attorney?
Yes.
You have a right to submit relevant documentary evidence, for example, letters or other written documents. Do you have any relevant documentary evidence to submit?
No.
At this hearing, you have the right to call voluntary witnesses and cross-examine diverse witnesses. Do you have any witnesses testify today?
No.
Are you prepared to proceed with the hearing at this time?
Yes.
So I will review each charge and inform you of the information underlying the charge. If you choose to make no reply to the charge, the hearing shall proceed and my decision will be made based on the information available. At the conclusion of the fact-finding portion of the hearing, I will inform you of my findings. The hearing will be then turned over to the board to consider your suitability for re-release. So the testimony at today's hearing will be taken under oath. Can you please raise your right hand, Mr. Christopher? You solemnly swear, solemnly affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
So I'm going to read the charge, which is charge number 1, new conviction on 11/14/25. Mr. Christopher was released on the community release to the Chase Center halfway house on 1/19/26. Mr. Christopher was signed out for his path at 10:34 a.m. and returned at 11:45 a.m. Mr. Christopher failed to return as scheduled. Connecticut State Police were contacted. The offender was considered an escape as he made no efforts to contact parole or the halfway house. On 2/4/26, was Hartford Police notified the parole officer that Mr. Christopher had been arrested for interfering with an officer resisting larceny motor vehicle first offense and larceny second. On 6/26/25, Mr. Christopher was arrested for escape first. On 6/9/2026, Mr. Christopher pled guilty to larceny motor vehicle first offense and was sentenced to 3 years jail, execution suspended with probation for 2 years. The other charge is nolly. On 7/20/2026, Mr. Christopher was convicted of escape first and was sentenced to 1 year jail, execution suspended after 5 months, 1 day conditional discharge. This is served consecutively. Would you like to respond to that charge, sir?
No.
Do you admit that you received these convictions at partial admittance, or do you deny?
Yeah, I admit.
Full admittance?
Yes.
So what I'm gonna do next is I'm gonna announce my findings in regards to that charge. So I do make a finding violation on that charge, 1 new conviction. This is based on your admission of guilt as well as your conviction and the evidence provided. So that includes the fact-finding portion of the hearing. So should you be re-paroled, where do you plan to live, or do you have any employment options?
Not no employment options, but I have been getting information about certain jobs that I will try to contact when I get home, whenever I get home, but I'll live with my grandmother.
What's your grandmother's information for where does she reside?
94 Elmwood Ave in Waterbury, Connecticut.
What's her name?
Deborah Christopher.
You have her phone number?
It's 203-519-9477.
And can you tell me about the employment opportunities that you have just mentioned?
It was one in Shelton. It was Oak Ridge. I guess I think it's a trash job, like a garbage man job, something like that. And a warehouse job. I don't remember the name off the top of my head, but I have it written down in my cell, in my notebook.
Okay, is there anything else you want to say in regards to your release plan? Do you have any other plans for when you are released eventually?
Not really.
Okay, so Mr. Christopher's voted to parole date was March 14th, 2026. His new parole eligibility date is November 26th, 2026. Mr. Christopher, I did want to note that that is the correct date, 11/26/26 for your parole eligibility date, because it is 85% based on your current charge that you are currently incarcerated for. And your EOS date is currently May 21st, 2027. So I'm gonna now turn it over to the panel chair.
Thank you. All right, Mr. Christopher, so I'm very disappointed to see you here. I don't know if you remember me, but I was part of the panel that voted you to parole.
Yes.
Yeah. So, I mean, do you care to explain what was going on, why you only lasted community release for a couple months?
I really can't explain. I was just going through a lot. I mean,
I don't know what that means, sir.
Like, I wasn't getting the help I really needed. I was trying to get help, but it's the people, they wasn't helping me. But I can't blame the people because I wasn't really applying myself for the help.
What kind of help did you need that you weren't receiving?
Medical insurance, they wasn't helping me with medical insurance. I asked them about certain jobs. They would tell me to go to American Job Center and on Watertown, I believe it was. Thomastown Avenue. Yeah, they wasn't helping me get nowhere. They basically wanted me to sit in there and just
wait. Were you getting passes yet?
Only to a program. That's it.
Did you have access to a computer or a tablet or a?
Yes.
Right, okay. So I know you're young. You're 21 years old, right? But it's time for you to start being more independent, right? And do things for yourself. If they're referring you to a job center, that's so that job center can help you look through jobs. I mean, what did you expect them to do? Apply for you or hand you a job on a platter?
I mean, nah, not necessarily. I would think they would have like certain job opportunities, like here, call this place, they're hiring, but it was just sending me to a building so they could help me.
Yeah. That's called a referral. I mean, what would you have done if you didn't go to a halfway house? You'd have to go out and apply for jobs, right?
Yeah, yes.
Okay, so because things weren't happening, and it was only 2 months. So because things weren't happening quickly, you got frustrated and you left?
Yes.
Wow. Okay. And where did you go? Where were you staying?
I was outside. Like I really wasn't staying nowhere. I was like.
Where were you sleeping?
House. People's house, friend house, here, mom house, aunt house, like.
Okay, then you were staying somewhere, right?
Yeah.
Okay, so why don't we just be honest here and cut through the nonsense, Mr. Christopher? You didn't want to be at the halfway house.
I didn't.
So why did you go there to begin with? Did you ask for a halfway house?
Yeah, I was asking because I knew it was opportunities, but the opportunities wasn't getting handed to me, so I got mad.
Yeah. Well, you're showing your age there, that's for sure. And then while you're on escape status, you steal a car. Why?
I can't explain that.
Well, you're gonna have to.
I was just my thoughts and actions. I couldn't. It was just a one. It was just a thought. Like I don't know how to explain it for real. It was just I don't know why.
How did you choose the car that you stole?
I ain't choose it. It was just on.
Well, that's how you chose it. You saw a running car, so that was your opportunity to take it?
Yes.
Wow. What kind of car was it?
A Honda.
Okay. And where was it? You just happened to be walking by it?
Yeah.
I don't know. Like, none of this is making sense to me. It sounds like you were sabotaging yourself. I mean, did you really think you weren't going to come back to prison?
Nah, I knew I was because it was a warrant for my arrest. I know that, but I don't know. I just started digging, making it deeper. I started digging myself deeper.
Yeah, right. Why would you do that?
I don't know.
Because if you had just
scared.
returned to the halfway house, then maybe they would have given you another chance, or, I mean, there's a million ways you could have handled this differently. Okay, and then you come back to prison and you have a new ticket for assaulting someone. Why?
I had got threatened, and I felt that was the best option.
Someone threatens you, and your best option is to beat them up?
Yeah, because if I go tell the COs, then people are gonna try to threaten me even more. I'm not trying to get threatened by everybody. Just I had to handle the one situation.
What was the threat about? Did you know this person?
Nah, not really. He was some older guy. I don't know I don't remember what was said, but I remember something about he said he was gonna do something to me. So I just.
What did he say he was gonna do to you?
Say he was gonna kill me.
Why?
I don't know.
I mean, really, the only one you harmed ultimately is yourself. Now you're sitting in, I mean, do you like it there?
Nah, not at all.
Your instant offenses were very serious. These are serious offenses. Shootings. I mean, we gave you an opportunity because you were doing so well in the your original sentence. I don't understand what happened. Maybe you weren't ready to go back out.
It was just the plan I had, it didn't work. So I started trying to find things and it just kept getting worse and nothing was working. So I just ended up.
But you
Just end up
understand
getting-
that's life. And given your
Yeah.
history, that will continue to be your life. There will be obstacles that you have to overcome. There's going to be setbacks. It's going to happen again. So you have to think about how you're going to handle it differently. You can't just go out and commit crimes because you're angry. You know, you have you sat down and come up with a plan for yourself? And the plan should include option B and C and D if it doesn't work out. Have you done that?
I have got a plan A, but you right, I should make a plan B and C. My plan A was to go home, go to Goodwill, fill out a resume the best I could to my abilities of what I have done. I heard you could use certain things from in here like kitchen jobs and janitorial jobs.
Yeah.
You could put that on the resume. I didn't know that when I was in the halfway, but now I know that.
Did you ever make it to the American Job Center that they sent you to?
One time.
Maybe if you kept going, they would have helped you with that resume and put all that stuff on there.
Yes, you're absolutely right. They would have.
I really think that in the time that you have, you're not even eligible until November, the end of November. So you can't go anywhere. In the time that you have left, you really should write down your goals short term, like this. You didn't give yourself a chance. In 2 months, you can't expect a whole lot. But you should write it all down and have backup plans and another backup plan and try to come up with other ideas. And what about school? Have you thought about, I know you got your GED, this incarceration.
Yes.
Have you thought about going for a trade or CDL or other kind of schooling?
Yes, when I was in the halfway, I had applied for HVAC. A friend gave me a hint about HVAC. They was giving them out free, but it was in I think it was in Newington. It was somewhere in the Hartford area. But
Right.
I don't think I didn't ask the halfway house if I could be able to go there.
Well, you could ask. And if it's a no to that, maybe there's something locally that's a similar program,
Yes.
All right. Mr. Zarkov, any questions?
I don't think I have any questions. Thank you.
Thank you. Ms. Keys?
Thank you. I think just one, for one, it sounds like self-advocacy, like asking questions, just keep asking people, and the more you learn, the more it'll help you. But for a question, sounds like maybe you're still acting impulsively. Does impulsive sound right to you?
Yes.
Making decisions quickly, yeah. And that could be, as my colleague mentioned, kind of an age thing, but maybe working on some skills to pause before you act on a decision. And so you did take complete good intentions, bad choices. What about new thoughts? You never took new thoughts, did you?
No.
Okay.
I had went twice, but I had ended up catching a new ticket, and then they had moved me to this jail.
Oh, okay. Oh, that stinks. Yeah. It sounds like if you could somehow try to get yourself to pause before you act and think about your goals and then the potential consequence of the act you're considering, like the DR,
Yes.
because you're worthy of this working. But you need to commit to yourself to do it, right? So pausing before you act, and then, like my colleague said, having a plan. And once you have these goals, then hopefully you can think of those goals. But all right, thank you. That's all I have for questions. Thank you.
Are you in the RT Springs?
No, but I could.
Yeah, are you earning ref time?
No.
Is it because of your ticket?
No, it's the mandatory. I had a mandatory minimum 5 years on my first sentence.
Right, that's right. Yeah, he's 85 or with a mandatory minimum. Okay. No. All right, give us a few minutes to discuss your case, okay? You can listen to us, just don't interrupt, and we'll give you our decision shortly. So this is a dilemma for me, and I'll tell you why. I like Mr. Christopher, and he's such a young guy, 21 years old, but just making very poor decisions, horrible decisions. I don't know. I mean, he's not even eligible till the end of November, so that would give him less than 6 months on parole. I don't know what they could do to help him in 6 months, and quite frankly, I don't know that he deserves that 6 months either. Given the fact that he was only out 2 months before he escaped. I mean, he knows the rules. He took his chances. He knew he was coming back to prison, but furthered that by stealing someone's car. And I don't think young people that we see consider the harm. It seems like no big deal, right? It's a nonviolent offense. But when someone's car is stolen, then they can't go to work. They can't take their kids places. It's a ripple effect. Our insurance goes up. It's just a nightmare. It's a big deal. We can't just, it's the middle of the winter and someone can't warm up their car because they have to worry about it getting stolen. My vote would definitely be to rescind. I don't know. I guess I could consider. I just don't know if there's any point in re-paroling him for 6 months at this point. What are your thoughts, Mr. Zarko?
Certainly share the concerns.
Yeah.
We'd hate to see young guys in prison to begin with.
Right.
21 years old.
Right.
And my vote will be to rescind the parole. He does have 3 years of probation.
He does,
Have used that time, this time, to prepare himself.
Right.
Come up with a solid release plan.
Yeah. Yep.
And follow through and do what he needs to do on probation.
Yeah.
Come out just still going to be very young.
Right. Very young. Yeah. Ms. Case?
Certainly growing up in prison in a sense, when you're that age, there's a little delay probably, and then acclimating again to the world and being, adapting to those rules and expectations of behavior. But I do agree with the rescission. I'm also similarly a little torn on the opportunity for 6 months of parole. I mean, honestly, tighter, as long as he doesn't escape, as long as he gets and just stays in it and keeps asking parole for assistance, asks halfway house if he's in halfway house for assistance. And
No, he's out the other sponsor, so he wouldn't go back there. Well, assuming the sponsor panned out, but he wanted to go to his grandmother's house.
Which is a nice.
You know what? I'm gonna stick with the rescind and max. I don't think he's ready. And the explanation for the ticket was concerning as well. I mean, I think it's a life lesson here. People can say whatever they want to. It doesn't mean you can attack them. This was true assault. It wasn't a fight. All right. In the matter, and he does have 3 years of probation. That's a good reminder. So he'll have support and services. In the matter of Javion Christopher, MA number 438763, I'll make a motion to rescind parole with no new parole date. Is there a second?
Second.
All in favor?
Aye.
Aye. Any opposed? No, it's a unanimous decision. All right, Mr. Christopher, couldn't give you a new parole date given, I mean, really our hands are tied here with your new crimes and the limited amount of time left, but I would highly recommend, because you do have probation after your sentence and they can help you as well, but take the rest of this time to come up with a good plan for yourself, and use the tablet, get out there. Like you said, you started looking at jobs, do a little further research, look into that schooling. Where did you say your grandmother is? What town? In Waterbury. Yeah, there's a lot of local programs here. So look for them, ask for them when you get out there, and we wish you the best.
Thank you.
This concludes the hearing for J. John 438763. You're all set, sir. Wish you the best.
All right.